my lord, my lord. Lord, this matter, this is in fact, it will be appropriate to call it third round, my lord.
All right.
In 2001, a writ application was filed alleging that the Baleshwar municipality has constructed a dam, constructed a shopping complex over the drain, my lord. That writ application was disposed of, my lord. Your lordship may kindly see, I have quoted the order in page 4, paragraph 6, my lord. Has your lordship got it, my lord? Page 4, paragraph 6, my lord.
Yes.
The writ application has been filed, which is simply by issuing the opposite but not to make any construction over the drain. It is not clear to whether the drain is situated over the entire plot number 184. Be that as it may, without entering into the arena of controversy, I feel that the opposite party, number one, being a body and a statutory authority, shall not make any construction over public drain. Mr. Mukherjee, Land Council, appearing for the opposite party, is also assured that this court that shall be no construction over public drain. In view of the aforesaid assurances made by the Land Council for the opposite party, I dispose of this writ application with an observation that the opposite parties shall not make any construction over any public drain, and if any construction has already been made, they shall be removed within a period of 6 months. But this was not implemented, therefore the petitioner filed petition number 56 of 2002. In the contempt petition that has also come before your lordship today, in the contempt petition, your lordship was pleased to direct the Tahsildar to make an inquiry and file an affidavit. Now, Tahsildar has filed an affidavit under Annex 4 and 5, my lord. But has stated that though it has been constructed over 22 decimals of the plot 184, which is recorded as a non-injury, but it doesn't create any obstruction and it doesn't create any inconvenience, my lord, and therefore he has stopped it there, my lord, because there was no direction to the Tahsildar to remove. Now they have not filed a counter as yet, my lord, and 11 years has passed, my lord. I leave it to your lordship, my lord.
Yeah. Because what's the point in now going in? Because the shops must be working for the last 11 years now.
Well, that is true, but there was a direction of this on the
I know, but if it is not brought in good time, sir, all this cannot be now asked to be done. You see,
how can there be a drain, my lord, over a public complex over a public drain, my lord?
Anyway, sir, you see, this is the third round of litigation concerning the petitioner's grievance about construction of shop rooms over a public drain in Baleshwar by the Baleshwar municipality. In Baleshwar, full stop. The grievance is that the Baleshwar municipality did not take action for removal.
No, Baleshwar municipality has constructed, my lord. That is
construction by the Baleshwar municipality. The grievance is that the construction was unauthorized and ought to have been removed. Paragraph. Initially, the petitioners had filed writ petition civil OJC number 8726 of 2001, which was disposed of on 4th October 2001, recording an assurance of council appearing for the municipality that there would be no construction over the public drain. Full stop. When the said assurance was not adhered to, contempt case CONTR number 56 of 2002 was filed, in which a report was called for from the Tahsildar. Full stop. Pursuant thereto, on 12th November 2003, the Tahsildar submitted a report confirming the construction of the shopping complex, and further admitting that there was no instruction given by the Tahsildar. No, as stating that the Tahsildar had not given any express permission for the same. Full stop. However, it was stated that the width of the drain is 4 feet 10 inches and there's a concrete slab and there is no permanent construction over the existing drain. Full stop. it is stated that there is a gap between the two shopping complexes and that the shopping complex was already constructed in the year 92-94. Considering that the shopping complex has been in existence for over 30 years now, the court is not inclined at this stage to issue any further directions in the matter. The municipality will ensure that the drain is not obstructed in any manner because of the existence of the shopping complex. The writ petition and the contempt petition are accordingly disposed of.
Item may kindly record on behalf of the municipality.
All right.
Item number 2.
I am for Vishal Dev. I have filed my name will be noted.
All right. All right.
Item number 2.
None appears dismissed.
Weekly list item number 3.
I am permitted to withdraw.
Counsel for the appellant seeks leave to withdraw. Dismiss, withdraw.
Weekly list item number 4.
None appears dismissed.
Item number 5.
None appears dismissed.
Weekly list item number 6.
Lordship, item number 6, let it come on next week. Ms. Senior having some personal difficulties.
What's the matter about? Tell us what the matter is about.
I have not gone through it.
Then pass it over. Just tell us what the matter is about. Pass over.
Lordship, item number 70, I have no instruction.
70.
Yes, 70.
No instructions. 6 is passed over.
Okay.
Item number 7.
My lord, in this matter is in
Dismissed.
Weekly item 8.
None appears dismissed.
Weekly list item 9.
Here, my lord, earlier, this honorable court in WPC number 13311 of 2016 directed the state government to decide to pass a regent order on the representation with a specific observation that has been quoted as 9, my lord.
Anyway, representation to be considered. Yes, a representation to be considered.
But there is a specific observation. That part, my lord, may kindly be looked. That starts from the page 9, my lord. The petitioners are villagers of Jungapalli. The district level committee as well as village level committee recommended for bifurcation of Jungapalli Gram Panchayat and creation of new Gram Panchayat having population 4649. The said newly created Jungapalli Gram Panchayat will consist of villages Tal, Jungapalli, Dabulbahal and Gudimal. Accordingly, notification number 272/2016 was issued by the state government. However, 20 days thereafter, for regions based known to the opposite party number 1, a fresh notification has been issued making Tal as the Gram Panchayat headquarters by renewing newly created as Tal Gram Panchayat. The notification dated 21/7/2016 does not contain any reason for changing the earlier decision of the constituting Jungapalli as the Gram Panchayat headquarters. This is the specific observation. On this observation, direction was issued, my lord, and the order was passed. That is, my lord, at page 50, my lord. And
So it's only about headquarters.
My lord.
Whether it should be Jungapalli or Tal.
My lord. Earlier notification, specific notification, what is Jungapalli?
What's the distance between the two, sir? What's the distance between Tal and Jungapalli?
My lord, so far as Tal is concerned, it is an extreme corner of that panchayat, my lord.
Sir, I have no idea, sir. I don't know which is corner, which is center. I want to know the distance.
Exact distance.
You have to help us, sir, because I'm new to Orissa. I'm not familiar with these areas.
But the guideline says.
Maybe I think Justice Dash probably knows how far Tal is from Jungapalli. Will he know?
Exact kilometer, I cannot say, my lord.
Who will know, sir? Who will know?
But the notification says
who will know? What is the distance? We can pass it over. You have a mobile phone, no?
Yes, my lord.
And somebody there has a mobile phone.
My lord.
So we'll pass it over.
My lord.
Just ask them what is the distance.
Item number 10. Item 10.
11.
10 no.
No, none appears dismissed.
Item number 11.
11 for infractuous.
Infractuous, all right.
Minor,
Item number 12.
WBC 3.
We are in a different list. We are in a different list.
Weekly list item 12.
May I please, Your Lordship? Your Lordship, to appraise the matter, Your Lordship may kindly have a glance at the last order, that is order number 3 dated 22 March 2017, Your Lordship.
Yes.
Your Lordship, it says that there was the submission of learned counsel of the appellant is that plot number this of khata number this belongs to appellant and is so recorded in the record of rights. In support of his submission, the appellant documents
They
filed.
have not filed a counter.
No counter.
So we'll make this absolute, sir.
My lord, let me take instruction. What is the status actually? After so many years, this matter is listed.
No, but no counter should have been filed, sir.
There is a letter that the Tahsildar has requested this office to.
No,
file
there is a stay of raising construction on 1237. That stay has continued. It was supposed to be constructed in the neighboring plot, 1244.
My lord, there is a.
His plot is 1237. So there is a stay on that construction in his plot.
Yes, there is a stay, but.
We'll make that absolute, sir. That has continued for 5 years now.
No, there is no instruction in the file.
Correct.
Yet.
You say on 22nd March 2017, the following order was passed by the court. Paragraph: in the last 5 years, no counter affidavit has been filed by the state. Full stop. The court therefore proceeds on the presumption that plot 1237 belongs to the appellant. Full stop. Since there has been a stay on construction of the said plot for over 5 years now.
My lord, there is an instruction in the file. As I have received from the Tahsildar on 29th March 2007, submission of here the instruction is that the plot number 1237 and 1244 are adjacent plots, and the Anganwadi center is under construction in plot number 1244, which is a government land. In this case map of both the plots are attached and next. The above two plots shows the period. It's not to grab the value. The case Donda can be alienated on the provisions of. There is a Anganwadi center to be
on 1244, not
yes,
1237. Right. You say the instruction of. Then
I am giving this instruction.
All right. You say the written instructions received by Mr. Mohanty, learned additional government
from the Tahsildar Khali Court.
From Tahsildar Khali Court is that
letter number 1797 dated 29th March 2017.
That the construction of the Anganwadi center is happening only on plot 1244 and not 1237. In that view of the matter, no further directions are required to be issued. The petition is disposed of.
Weekly list item 13.
Your Lordship, matter has become infructuous.
Infructuous dismissed.
Weekly list item number 14.
Permitted to withdraw. Permitted to withdraw.
Weekly list item number 15.
I am appearing for OP number 5.
None appears dismissed. None appears to the appellant dismissed.
Weekly list item number 16.
Delay.
And then
Ajay, 397 days delay unexplained. MC
sir,
is dismissed.
I'm very sorry, sir. 16 is state is the appellant.
I know, 397 days. Sir.
397 days.
All right.
Weekly list item 17.
Lordship, item 17, I am for the appellant. This is writ appeal number 75 of 2017. This is a very short point. I am a clerk meter reader who is retired. I was to avail a time-bound assured carrier progression scheme, time bound, wherein in 10 years, 15 years, and 30 years of my service, I get little increment in my pay. It has nothing to do with any other 2000 revised scheme. It is only time bound. So after 30 years, when I completed 30 years and on superannuation, I applied for this scheme, and the department tells me, or rather the opposite party number 3, that you did not pass an examination for which you were not eligible for this.
The ground is delay in latches, sir. Come to para 16.
I understand, Lordship, that the learned single judge has said that there is a delay.
Right.
I'll just try to satisfy your Lordship. This is a poor gentleman. I called him yesterday and asked him that why was it 3 years late. Said he lives in Balasore and he's cultivating his lands there. So he could not get
there, sir. Let him peacefully be there. Why bother about all this?
He would totally. I was calculating yesterday some 12,400 rupees he'll get if it is that's all. I mean, totally 12,400.
Who's for the NESCO?
I am for the opposite party NESCO. Now the establishment status has been changed since 1/1/2020. And second,
Tata has taken over.
That is the first aspect. And second aspect, my lord, that is similar cases has already been dealt with by the Congress at par with other two category employees. And this is the, my lord, what happens. This is he has no, so far the rule is concerned, assured career progressive scheme is concerned. The person, there are 3 stages it was given. Now he has already availed all the scheme, my lord. No. And there is in the when it was introduced in 2013, there is a scheme for option. He has not exercised option, but he has given it first time in the year after completion of 15 years, thereafter 30 years. But he has not exercised option. If he has exercised option, some amount was deducted and face will be calculated and scheme will be given. For that reason, single judge has disposed the matter negatively against the person. Now, my lord, I am preparing a comparative statement, my lord. If that is the true writ application, which, my lord, can you see in the comparative statement, it is clear that he has no requested qualification to avail second, third RSC. Career aggressive progression scheme, my lord. That is the scheme, my lord.
But I am not in this scheme. I am in the previous scheme, which is the time-bound asset.
That I am seeing. That is the career progressive asset scheme. First of all, my lord, one case is Ashwini Kumar Das, Clerk B, and Gopal Chandra Shetty, Clerk B, and Pranam Kumar Dalal, Clerk B. He is the clerk, Pranam Kumar Dalal, Clerk B. My lord, in that statement I am reading, SCP concept came into...
It's all right, sir. We're not interfering. You say the appeal is directed against a judgment dated 3rd December 2016, passed by the learned single judge, dismissing the appellant's writ petition civil 27702 of 2013. In the writ petition, the appellant had questioned the action of the then opposite party, Northeastern Electric Supply Company of Orissa Limited, (NESCO), in not granting him the time-bound third assured career progression, (ACP), in the revised scale of pay. Paragraph. At the outset must be mentioned now that NESCO has been taken over by the Tata
Power North
Orissa Distribution Company Limited since 2020. Full stop. Meanwhile, the appellant is also superannuated. It is further seen that the appellant's claim itself was barred by delay in latches, as noted by the learned single judge in para 16 of the impugned order. Paragraph. Consequently, the court is not persuaded, in view of the above circumstances, to interfere with the impugned order of the learned single judge. The appeal is dismissed.
List item 18.
18, my lord, on behalf of B. Das, my lord, is a yield, my lord. So it was taken next week, my lord.
My lord,
what's the matter about, sir?
Government quarter, everything not passed.
No, my lord.
And no state. He has given undertaking before the honorable single judge that he will vacate that. I think whether he is continuing in the quarter or not.
We don't know, but there's no stay here.
What I'm
There is
saying,
no
my
stay.
lord, my lord, petition is dead, my lord. I have filed a substitution.
Where's the question, sir?
My
Water being evicted?
No, my lord. That is my private building.
There is no stay, nothing, sir. So, which means you're continuing with nobody's disturbing you.
My lord, what I'm saying, my lord, the petitioner is since I have filed all the document, my lord.
Let's read the impugned order, sir. Page 15. Come.
My lord,
Page 15, please complete.
My lord, just
Second para.
No, let him read the old order, sir. It's such a short order.
my lord, that has most probably is wrong dictation, my lord.
Let's read it, sir. Right or wrong, let's read the order.
From the beginning, my lord.
Sir, it's not a very long order. It's just 2 paragraphs. Please read it.
This writ petition has been filed as selling the order under Annexure 1 to this petition passed by the Director of State Bhubaneswar in appeal case number 28/13. Going through the pleadings made in this writ petition and after perusing the impugned order, this court finds the petitioner has illegally occupied the disputed site since long and in spite of an order passed since 2013 involving the appeal, he is not vacating the disputed site. Considering the submission made by the learned counsel for the petitioner and as the petitioner is still in occupation of the disputed site, in spite of repeated orders for vacating the disputed site, but however, considering that he is still in occupation of the same, this court dispose of the petition, granting liberty to the petitioner to vacate the disputed site within a period of 1 month, hence subject to his filing an undertaking with affidavit before the competent authority within 7 days, indicating that he is undertaking to vacate the quarter within 1 month, my lord.
So when was this order passed?
My lord, on 7/3/17, my lord.
How many years have passed, sir?
My lord, I have filed my immediately read
Very
appeal,
good. But is there any stay of this order?
my lord. What I'm submitting, that is a civil suit is pending, my lord.
Very good, sir. Then you pursue that.
What I'm, my lord, is not the order, my lord. Director of State have passed the order, my lord. Wrongly, my lord. I have filed all the documents that I am in adverse possession, and previously my father is in possession, my lord. I have annexed, my lord. Your lordship has a glance at page 23. Annexure 3, my lord.
Who has filed the civil suit, sir?
I am the petitioner, my lord.
He has claimed adverse possession over a government part.
Right.
But that is the claim.
My lord, but direction has been given and the commissioner police has been.
See, they are so kind to you, sir.
My lord.
The judge wanted you to vacate within 1 month, subject to filing undertaking, correct?
My lord.
So they are so kind. Till date, they have not touched you.
My lord.
You're not able to follow anything. Sir, are you not unable to follow anything that I'm saying?
My lord,
every time I ask you a question, you're saying you're asking back a question. You're not able to follow anything that I'm saying.
Following, my lord. I have filed all the documents, my lord, that regarding my occupation. I have constructed a building, my lord. I have that challenge. I have challenged in civil suit, my lord.
Very good, sir. Very good. You pursue that civil suit. All right.
That director of state has no power to direct me to vacate the land.
Correct. You say the challenge in the present petition appeal is to an order dated 7th March 2017, passed by the learned single judge, dismissing writ petition civil, disposing of writ petition civil 1770 of 2017 filed by the present appellant. Full stop. Paragraph. In the said writ petition, the appellant had challenged an order dated 10th October 2018 passed by the Director of Estates Bhubaneswar in appeal case number 28/13 rejecting the challenge to an order dated 27th May 2013 of the estate officer, requiring the appellant to vacate the government quarter.
There is no construction at all there.
Full stop. The learned single judge has, after noting the pleas of the present appellant, has come to the conclusion that the appellant has been illegally occupying the disputed site since 2013 without there being any order in his favor. Since he continued to be in occupation, the learned single judge granted in the indulgence of vacating the dispute site within a period of 1 month from the date of the order of the single judge, subject to the appellant filing an undertaking before the competent authority within 7 days. Paragraph. The appellant did not file any such undertaking. In the 5 years since the pendency of the present appeal, there has been no interim order. Paragraph. Meanwhile, the appellant has expired. Full stop. Made by counsel for the appellant, it appears that his family is still in occupation of the disputed site. Full stop. This is plainly untenable in law, particularly since there has been no stay of the impugned order of the learned single judge. Paragraph. Be that as it may, it appears that a civil suit had been filed by the appellant even during the pendency of the eviction proceedings before the estate officer. Full stop. The appellant is apparently has set up a claim on property on the basis of adverse possession. Paragraph. With there being no merit in the present writ appeal, the court is not inclined to interfere with the impugned order of the learned single judge. Stop. The appeal is dismissed. No other assist cause.
I mean, pardon to mention one line, my lord, that order has been impugned order. What court below has passed, that much prior to that case, the civil has been held.
Very good. Very good. All right.
Item 19.
Delay.
31.
Delay is only 21 days.
All right. Delays control. Tell us, sir.
That your lordship may kindly have a glance over the impugned order.
Yes.
Dated 8th February 2017.
Right.
The state was the petitioner before the Honorable Single Judge, challenging an order passed by the Commissioner of Consolidation and Settlement under the provisions of Section 15B RP case. And the main point before the Honorable Single Judge was that the delay was condoned by the Commissioner without hearing the State Council, number one. Number two, and the matter was also heard without the participation of the State Council. Basically, we have approached the Honorable Single Judge for remand of the case for re-hearing, and that was not denied by holding that there was sufficient opportunity was given to the State Council.
Correct. This is all factual, sir. So you say the challenge in the present appeal is to an order dated 8 February 2017, passed by the learned single judge, rejecting writ petition civil 14468 of 2012 filed by the appellant, questioning an order dated what's the date of the order? February 2011, passed by the Additional Commissioner Settlement and Consolidation, Cuttack, in RP case number 609 of 2009, paragraph. There were two grounds urged by the appellant before the learned single judge. First of one was that the delay in filing the revision petition, the respondent filing the revision petition had been condoned without notice to the parties. Secondly, it was contended that there was no appearance of the state in the revision petition, and it had been decided in its absence. Paragraph. The learned single judge, having perused the records and the entire order sheet, found factually that the presence of the counsel for the state was recorded in those proceedings. Consequently, factually, it was not correct that the impugned order by the Additional Commissioner had been passed without participation of the State Council. Full stop. Further, it was found that a portion of the very disputed land had been acquired, and for which land acquisition proceedings had been initiated, and compensation paid to private opposite parties. Full stop. For this reason also, the claim of the state was be untenable. Paragraph. Having heard learned AGA for the state and having produced the impugned order, the learned single judge and the documents and record, the court is unable to find any ground to interfere with the order of the learned single judge. The appeal is accordingly dismissed. No orders is to cause.
Item number 20.
None appeals dismissed.
Item number 21.
20, my lord, item 20, I'm appealing for the opposite party. Not
All right. None appeals for the appellant dismissed.
21.
20, my lord. I'm appealing in 20.
Is 20. 21.
No, 20.
Wasn't
21. Item 20.
None appeals dismissed.
For the respondent opposite party number 4.
All right.
Item number 23.
None appeals for the appellant dismissed.
Item number 24.
May it please your lordship, that I'm on virtual mode.
Item 24, 25, 26, 27, 28, and 30. But that trade certificate tax matter.
I see. List along with
5th December.
5th December. Let's put the numbers and say 5th December.
It's WA 2017.
Right.
223 of the 17.
All right.
Item 41 also, sir. Item 41 also.
41.
Sir.
All right.
Item 29.
Obliged.
None appeals dismissed.
Item number 31.
31. State is the appellant.
No delays. Yes, sir. Tell us what the matter.
That is Panchayat Samiti matter. I think this has become
infractuous, no?
Infractuous.
All right. Due to passage of time, the petition has been, appeal has been rendered infractuous, disposed of as such.
Because another election has already been held in the meanwhile. Panchayat Samiti election.
All right.
Weekly list item 32.
Yes.
I'll just give a brief background of the case before coming to the impugned order. The petitioner had applied for a cinema license before the collector Jharsuguda, which was rejected that on the apprehension there may be some traffic issues. Then I had preferred a statutory appeal before the RDC, which was allowed taking into consideration that there is sufficient space and everything. Now the private respondents filed a PIL before this honorable court, suppressing that appellate order, that their students are studying in a school which is coming within 100-meter radius of the cinema hall. Now, when I appeared, I brought to the knowledge of the honorable court the appellate order that they had suppressed it. So they withdrew the writ petition and took a chance that we will approach some authority concerned. I don't know which authority. They took a chance. Then again, they filed the same petition, same pleadings, but they listed the matter before the honorable single judge. It was filed as a PIL, and when the High Court rule doesn't permit it, it says that if a petition has been withdrawn, it will be listed before the same bench which had withdrawn. And they took an interim order that your cinema hall will not be opened. Then, and when I approached the honorable single judge and I brought all these facts, the honorable single judge, while the impugned order, he did a crime branch inquiry against me that he will go and measure the distance. Now, if your lordship may see my writ appeal, annexure 2, the collector had already measured the distance and it is 372 meters at page 19.
Right.
So they completely false submission that it is falling within 100 meters of radius. So they have virtually no case at all. And the honorable single judge directed a crime branch inquiry against me for reasons best known.
All right. The challenge in the present appeal is to an order dated 18 July 2017 passed by the learned single judge, disposing of writ petition civil.
It was an interim order.
Right. Oh, which was an interim order. What has happened to the writ petition?
It is still pending.
All right. 117071 of 2017, filed by the respondents. 8 to 11. Questioning a license dated 1st March 2017 in favor of the present appellant under Section 5 of the Odisha Cinema Regulation Act 1954 (Bracket Act) without no objection certificate. This of the Director General Fire Services, Odisha. Paragraph. It appears that it was in fact the second round of litigation. Stop. Earlier, these very writ petitioners had filed writ petition civil 11701. No.
3531.
Writ petition civil PIL number 3531 of 2017 as a public interest litigation. Full stop. The said writ petition was not entertained by this court, and by an order dated 15 March 2017, it was disposed of as withdrawn, with liberty to approach the authority concerned in accordance with law. Full stop. The claim of the parties responds 8 to 11, who filed the second writ petition, being writ petition civil 11701 of 2017, was that since the post of the Revenue Divisional Commissioner (RDC) Sambalpur was vacant, they were constrained to again approach this court. To stop this time, however, it appears that it was not projected as a PIL, and it came up before the learned single judge. Full stop. It is seen from the impugned order of the learned single judge that the petition was a PIL was perhaps not even taken note of. Full stop. It is also possible that the learned single judge's attention was not drawn to the earlier order passed, dismissing the earlier PIL as withdrawn. Full stop. Surprisingly, in the impugned order, the learned single judge decided to direct the crime branch in the bona fides of the petitioner in their standing, and also to stop. Then you say also to remove that. Where is that direction for measuring?
Sorry, my lord.
You said he had issued a direction to measure the distance. Where's that?
Directed the AD. What's the last, your lordship?
No. About measuring the distance, I don't see any direction for that.
No, Milad, there is no direction to measure it. It just
no. Acha. To furnish a report about the bona fides, right, there. And the distance of the
school.
The report is also asked to indicate the distance of the school in the multiplex in question. Paragraph. Counsel for the appellant has pointed out how the distance already was measured and found to be beyond the 200 meters.
100 meters.
Beyond 100 meters.
It was 372 meters
from the school. Stop. The court is of the view that in the above background, the learned single judge was not justified in issuing any interim order, particularly of the nature of ordering, but particularly by ordering the crime branch to examine the bona fides of the writ petitioners and also to undertake a measurement. Full stop. This was clearly outside the scope of the writ jurisdiction of the High Court. Paragraph. Accordingly, the impugned interim order of the learned single judge is hereby set aside. The writ appeal is allowed. No order systems.
My lord, I pray the writ is also, since it's a PIL, it's not assigned to the roster bench.
That is before the single bench.
That is also my prayer that it did not have the jurisdiction to entertain.
But he will have to say that. The matter now be listed before the roster bench of the single judge on 1 minute, on 14 November Full stop. The learned single judge will first inquire whether the writ petition is at all maintainable before the single bench.
It's because the High Court rules itself says if he files
you can
again.
point that out.
Yes, I'll point it out.
Wiki list item 33.
Yeah, please, Your Lord. I have challenged the impugned order of the Honorable Single Judge under Annexure 6, my Lord. But noting is that, my Lord, it is not back from the respondent number 1 to 4. There is stay, my Lord.
What is the matter about, sir?
My Lord. It is the ST portion, my Lord, scheduled tribe portion. He had purchased some land in 2005, my Lord. Thereafter, the respondent number 4 encroached the land without any permission, which is required under section 3 of regulation to 1956, my Lord. As the respondent number 4 encroached without any permission, my Lord, the petitioner, being the ST portion, approached the respondent number 2 by filing RMC case, my Lord. One miscase, my Lord. Under section 3A of regulation to 1956, my Lord, praying therein to restore the case land from the respondent number 4 in favor of the appellant, my Lord. Thereafter, the respondent number 2 directed the Tahsildar, the respondent number 3, to make an inquiry. Thereafter, Tahsildar directed the RI to make an inquiry. RI made an inquiry, that is at Annex 2, my Lord. Report dated 28/3/2012. And the RI clearly mentioned that, yes, the respondent number 4 has encroached the land of the appellant, my Lord. On the basis of which, my Lord, the regulation of 2011 was disposed of on 20th April 2012, my Lord, by the respondent number 2, that is at Annex 4, my Lord. The land was directed to be restored in favor of the appellant. Against that, my Lord, the respondent number 4 preferred appeal before the respondent number 1. Respondent number 1 also, after perusing all the records, materials on the record, my Lord, dismissed the appeal. Regulation of appeal number 5 of 2012.
So he went to the single judge after that.
Thereafter, single judge, my Lord.
And single judge allowed
there is a remand order. It is a remand order. The Honorable Court has directed both of them to appear before the authority and put forth their pleadings. And
no, but if there's a report in his favor, why should they go back?
That report is to be taken into account as per the impugned order also.
There's no need to interfere. If it's a report in his favor, where's the question of interference?
My Lord.
And the petitioner is to contest. I think nobody is.
The report subsequently, a fabricated report was prepared by the appellant, respondent number 4, and he filed that report for the first time in High Court, my Lord. But Honorable Single Judge did not take into account that aspect, my Lord. There was a report, my Lord, as per the order of the respondent number 2. That was not taken into consideration. The respondent number 4 was a false report on, I have filed that, my Lord, Annex 7. That is after the appeal was over, my Lord. He did not file that document before the original authority, neither he filed the same before the appellate authority, my Lord.
But he's that the report is in his favor.
There are 2 reports, my Lord. Annex 2, your lordship, may kindly say. That is
one is Annex 2, another
is Annex 7, my Lord.
4?
Annex 7. I have filed that at Annex 7 to the writ appeal, my Lord.
Tahsildar's report is in favor of your opposite party.
In favor of the appellant, my Lord.
No, Tahsildar's report.
Yes, my Lord. Your lordship may kindly see page, my Lord, 15. Page 15, my Lord.
No, just come to page 24.
Well, that is the subsequent report, my Lord.
That's right. It's the Tahsildar's report.
Yes, it is also the Tahsildar's report, my Lord.
No, come to page 24, sir.
Yes, my Lord.
Third paragraph, last line, referring to Tahsildar's report. Right, Annexure 4, favoring the petitioner. Petitioner in the writ petition was respondent here.
Respondent herein.
Yes, my Lord.
Referring to Tahsildar's report, with Annexure 4, favoring the petitioner, counsel of the petitioner contended that had the report of the Tahsildar been produced, then the decision would have been otherwise. So he's claiming the Tahsildar's report is in his favor.
Yes, well, this is the report prepared more.
So somebody has to consider both reports, the report in your favor, the report in his favor.
The original authority should consider both the reports. That is why remand order is justified.
Correct. The correct order, sir. The challenge in the present petition appeal is to an order dated 18 July 2017, passed with the learned single judge, disposing of writ petition civil 14024 of 2014, filed by the respondent, number 1. Challenging the revenue inspector bracket RI and the order dated 20th March 2015, passed by the ADM Sundargarh, in RA number 5 of 2012, confirming the paragraph. During the pendency of the writ petition, the respondent number 1 placed before the learned single judge copy of the report of a Tahsildar, which purportedly was in favor of the respondent. Considering that one report was favoring the present appellant and the other the respondent, the learned single judge has remanded the matter to the ADM for a fresh decision. While issuing notice in the present appeal on 13th March 2018, this court had stayed the operation of the impugned order of the learned single judge. Paragraph. Considering that there were two reports, one by the Tahsildar in favor of the respondent, number 1, and the other by the revenue inspector in favor of the present appellant, and both were by officials of the government, the learned single judge has rightly remanded the matter to the ADM for a fresh consideration of the entire matter and to reconcile the conflicting reports of the government officials, one in favor of the present appellant and the other in favor of respondent 1. So in the circumstances, the court is unable to find any error having been committed by the learned single judge in passing the impugned order. The appeal is accordingly dismissed. The interim order is vacated.
Item number 34.
May it please, my lord. Writ appeal, my lord. But pursuant to an allegation, my lord, against this appellant regarding submission of a fake caste certificate, a proceeding was initiated by the state level scrutiny committee, my lord. And an inquiry was directed to be conducted. In the inquiry, it was found out that the certificate is genuine. However, my lord, the final order was passed by the scrutiny committee, holding that the caste certificate was not genuine. But against that, my lord, challenging that order, this appellant preferred an application before the honorable single judge. But lordship may kindly come to the order, my lord. Impugned order. The honorable single judge did not go into the merits of the case and only stated that the appellant may move before the common law forum, challenging the order passed by the state level scrutiny committee. But in fact, my lord, this inquiry was conducted on the basis of the guidelines framed up by the Honorable Apex Court in the judgment, my lord, reported in AIR 1995 Supreme Court, page 94.
No, but why don't you move the state level committee? I mean, why don't you move the common law forum?
My lord, the only question is that whether the caste certificate is genuine or not. He has obtained the caste certificate on the basis of by showing that I am the adopted son of a scheduled caste person X. And so far as that adoption is concerned, the view of the honorable single judge is that since it is a mixed question of fact and law, you move because adoption issue cannot be decided in a writ jurisdiction. I think there is no error in the impugned order.
In fact, Lord, this
which is this common law forum?
Civil court, obviously.
Lord, that has been barred. Placed on record the judgment on the basis of which the proceeding was initiated. Lord, she may kindly come to page 7, where guideline framed to conduct inquiry, and the relevant page is page number 9. I have highlighted, my lord.
Annexure.
The order passed by the committee shall be final and conclusive only subject to proceeding under Article 226 of the Constitution. And the next point says no suit or other proceeding before any other authority should have.
That is a different issue so far as that
my lord may kindly
jurisdiction of the suit is concerned. Here is a case where your adoption is under challenge because
page 20 of my writ petition. On the basis of this judgment, proceeding was initiated. Lordship may kindly come to page 20 of the writ petition, Lord. The first paragraph itself indicates the judgment.
Your lordship is to see whether the committee can examine the factum of adoption, whether the committee is empowered under the law to declare that you are the son of adopted son of X. Because adoption is such an issue which is a mixed question of fact and law. Only the civil and there are certain decisions of our Honorable High Court that consolidation authority is also empowered to decide the plea of adoption. But except that, so far as this committee is concerned, even if the committee is not empowered, that is my respectful submission.
Only if it is the challenge, my lord. If the adoption part is under challenge, my lord, then the question will arise whether
that
I will
is your claim. That is your claim. Even if it is not challenged, that claim has to be substantiated by valid
consider these cases
of the court.
The Honorable Apex Court.
Then anybody can claim that I am the adopted son of some scheduled caste and scheduled tribe person.
The guidelines to deal these cases, and in that judgment it has been specifically provided to deal with these cases.
No, whether there's a valid adoption or not itself has to be a question, right? How can that be decided by the scrutiny level committee?
Yes, my lord, that has been decided.
No, how can the scrutiny level committee decide whether there's a valid adoption or not?
Yes, my lord, that could have been done by the honorable single judge, my lord, either rightly or wrongly. But
no, where's question of rightly or wrongly?
In fact, the question of adoption has not been gone into, my lord. That was an issue, but that has not been decided. And that was never under challenge.
Decided in the writ jurisdiction.
But my humble submission would be, had the adoption been under challenge, my lord, then the question would have arisen.
No. When you go before a state level committee,
but I did not
claim my humble submission son of a adopted son of a scheduled caste.
That is the report, my lord. The report, lordship sees the report, my lord. Under annexure 2, my lord, the report is categorically in my favor. It says that a certificate is genuine, adoption is correct, and that was never challenged. But unless the adoption is challenged, my lord, the question of legality of the adoption, Lord, my humble submission cannot arise, Lord.
Because
that is the report.
Because the state level committee did not grant you your request, you went in a writ petition.
Why?
What did the state committee say? Let's see that.
Yes, Lord. The final order at page 20, my lord. The relevant page so far as the operative part is concerned, that is at page 23. Under the above premises, having regard to the available documents, records and evidence and statement of the alleged before the committee, the state level scrutiny committee unanimously decided that the alleged belongs to.
This is an actual finding against you that you manipulated.
That is why you prefer the writ petition.
But I prefer the writ petition challenging the decision, but holding that my certificate is bad. But that certificate was issued by the competent authority, Tahsildar. But that was never challenged.
No, what do you mean by not challenged? When you apply,
my lord,
to be recognized as belonging to that caste on the basis of the Tahsildar's report,
my lord,
that's when they will examine whether it is a genuine thing or not.
My humble submission would be
not challenged.
Lord, my humble submission would be the appellant approached the Tahsildar to issue a caste certificate that has been issued pursuant to inquiry, my lord, by the revenue.
That has been overruled by the committee.
Not pursuant to an allegation.
Once the Tahsildar does it, it's a final. You cannot
pursuant to an allegation, my lord.
This report is not conclusive.
There is a parameter to be pursuant to an allegation only this proceeding was initiated.
Whatever, sir.
But on the basis, Lordship may kindly appreciate me, Lord, on this issue itself, but a judicial proceeding was pending. A proceeding under section 420 was also initiated against with respect to the self-same allegation. There I have been acquitted. The order is also there. Lordship sees annexure 3. But everything is in my Lord. And this person is in service, my lord. The report, Lordship sees the order, my lord. Annexure 3 at page 28, my lord. Their finding is the adoption was found to be genuine. There is a finding also. Lordship sees the relevant page, my lord. But all these issues have gone into, my lord. Lordship sees the.
This is a SDJM proceeding, correct?
My lord.
It's not a civil court.
Not the order in that was never an issue. Lordship sees. Lordship may kindly come to the report. Lordship may for a moment.
Say it has become an issue because of the state level scrutiny committee finding it to be a forged document.
Lordship may kindly come to Annexure 2, my lord.
Yes.
Annexure 2, Lordship.
Yes.
But this is the report, my lord.
This is what is being questioned, sir.
My lord, page 26.
Yes.
Towards the bottom, my lord, the conclusion, my lord.
Yes.
Annam Charan Naik, son of so and so, my lord, of village Kulia so and so, PS so and so, district so and so, caste Kumbhar, was adopted by Krutibas Naik, son of Idi Naik of village so and so, PS so and so, district so and so, of caste Dombo scheduled caste in the year 1965 when he was 7. But when there is no dispute, my lord, how?
No, there is no dispute that your adoptive father is a scheduled caste person. Admittedly, your natural father is a non-scheduled caste. You are claiming adoption to a non-scheduled caste person. That part of the adoption, that is the committee has disbelieved.
My humble submission would be
then
when my adoption is
adopted son
it is said that my adoption is not when my humble submission. Lordship may kindly appreciate, my lord, when the factum of adoption, which is found out from the report, my lord, which says that I was adopted, but certainly my caste, which it is Dombo caste, my lord, after adoption, but that is also not in dispute.
Is there a assumption of caste as a result of adoption?
My lord, what? But at the age when I was 7 months, my lord, I was adopted, and the report clearly indicates right from the date of adoption, I have been staying with my adoptive father and mother. I brought up as a Dombo caste, in a member of Dombo caste community, my lord, which is a scheduled caste, my lord. But there is no.
Anyway, you have only been asked to go to civil court. If your case is genuine, you will get a declaration from the civil court.
My lord, my humble submission would be, when my adoption is
the present writ appeal is to an order dated 28 June 2017, passed by the Lent single judge, disposing of writ petition civil 10819 of 2017, filed by the present appellate.
My lord, may just as a senior advocate, may I assist, my lord, your lordship permission?
Yes.
Because I have a case also 58. But here, the honorable single judge, instead of deciding on merit about the validity of the order passed by the scrutiny committee, rather stated that you go to common forum and that is barred under the Supreme Court judgment. So it is a question challenging the order of the scrutiny committee, which has not been addressed nor considered. No finding with regards to that, just it was relegated saying that common forum. So here the question of
the nature of the allegation, because it says that it was obtained by fraud.
I will give reply to my learned senior.
But with regards to that, must be a finding by the learned senior. Instead of deciding the matter, relegating.
No, the scrutiny level committee finds that's by manipulation and fraud.
Yes.
So this is a disputed question. So a single judge in 226 cannot adjudicate a disputed question which requires evidence to be led.
But only thing is that if that has been adjudicated at all, then this question arises. But instead of adjudicating on that issue, relegating that go to the common forum, which is barred under the Madhuri Patil case.
Yes.
Specifically. Only that your lordship may consider.
By the impugned judgment. No, the challenge in the writ petition was to an order dated 12th November 2015, passed by the state level scrutiny committee, rejecting the plea of the present appellant that he belonged to the single courts DUMBO. Scheduled caste. By virtue of full stop, the claim of the appellant was that since his adoptive father belonged to the above SC, he too is an SC belonging to the said caste. The SLCC on a thorough examination of the matter, came to the conclusion that the appellant belonged to the single quotes Kumbhara community and not not open single quotes DAMBO, Dumbo. And further concluded that the appellant, open quotation, has forged and manipulated his caste identity to avail the benefit meant for SC people. Paragraph. The learned single judge has, after noting the disputed questions of fact, obviously could not be examined by the learned single judge, relegated the appellant to the remedy in the civil court in order to establish his claim that he belongs to the Dumbo SC caste.
Being the adopted son of so and so.
Right. Since he was the adopted son of a person belonging to the SC. Paragraph. Counsel for the appellant relied on the decision of the Supreme Court in Kumari Madhuri Patila versus Additional Commissioner Tribal Development, AIR 1995-94, to urge that this question whether the order passed by the SLCC is correct can be decided and ought to have been decided only by the learned single judge in exercise of the jurisdiction under Article 226 of the Constitution, and ought not to have relegated the appellant to the remedy in a civil court. Paragraph. The court finds that in the aforementioned decision in Kumari Madhuri Patila Supra, the question whether as a result of adoption a person acquires the same the adoptive father was not under consideration. Full stop. Secondly, it does not appear from the facts of the said facts in Kumari Madhuri Patila bracket Supra that there was also any objection raised that the SC certificate had been obtained by manipulation, fraud, and forgery. Paragraph. These are indeed disputed questions of fact which cannot be properly adjudicated in a writ jurisdiction. Consequently, the court is unable to find any error having been committed by the learned single judge in relegating the appellant to civil court remedy. The appeal is accordingly dismissed. The interim order is vacated. No order is to cause.
Weekly list item 35.
35 perhaps become infructuous because it is election of Bhubaneswar Municipal Corporation.
None appears for the appellant dismissed.
Item number 36.
Item 36, my lord, infructuous.
Infructuous.
I am appearing for respond number. Respond number 2 HPCL, my lord.
Yes.
All right. Item 37.
None
37.
Item number 38.
37, your lordship. I am for the petitioner. Appeals to Regulation 2 of 1956. The order dated 6/7/2017, passed by the Honorable Single Judge, confirming the order of the collector, declaring the
37.
Yes.
Declaring the sale deed as null and void on the ground that the general proclamation was published by the competent authority inviting objection on 28/4/94, but permission was granted on 3/5/9, which is prior to the expiry of the notice period. That is the only violation, procedural irregularity committed by the competent authority. And on that ground, it was challenged before the Honorable Single Judge, and also it was reflected in the order that there was procedural irregularity. Statutory provision has not been complied with. In spite of this, the order was confirmed, which is under challenge. Your lordship may kindly see the relevant portion, page 15.
The notice period is short than the prescribed period as per the rules. That is the reason for which the Honorable Single Judge has said that it is invalid, the permission. 30 days notice is mandatorily required. Here is the 28/4/94 and 3/5. So only 5 days notice.
Lordship, this is procedural irregularity committed by the statutory authorities.
Whatever say, you can't take advantage.
Your lordship, if power is conferred on the statutory authority to do a certain thing, that must be done in that manner, not
other means. So your lordship I may cite a decision to that effect, is bound to do in that manner as prescribed by the law. Because it amounts to principle of violation of principle of natural justice as well as miscarriage of justice also. By mistake of the court, the citizen will not suffer, your lordship, will not be affected in any manner. Lordship, AR 1936 PV Council 253, who stated as under, where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. The same view has also been taken by the Apex Court in Babu, Bhargej and others versus Bar Council of others, AR 1999 Supreme Court, 1281 at page 1288. In view of the detailed procedure, envisaged under rule so and so, if the same has not been followed in letter and spirit as to the law discussed above, any action taken in violation of such rules cannot sustain in the eye of law.
Yes. The challenge in the present appeal is to an order dated 6 July 2017 passed by the single judge, dismissing the appellant's writ petition civil 11430 of 2000. Paragraph. The challenge in the writ petition was to an order dated
6th July 2017.
1 minute. No, the date of the order is 16 July 1999. An order dated 16 July 1999. Passed by the collector Rayagada.
Oh, collector, sir.
Declaring the earlier order dated 3rd May 1994 in OSA TIP case number 47 of 1994. Granting permission in favor of the present appellant in respect of sale of a plot of land measuring AC 2.79 in village Barikhal to be illegal. Paragraph. The learned single judge has, in the impugned order dated 6 July 2017, noted the illegalities committed while granting sale permission in terms of Regulation 2 of 1956, where there should have been a clear gap of 1 month from date of issuing the notice calling for claims objections from interested parties, that provision was not followed. Paragraph. Counsel for the appellant submitted that the collector could not have suo motu reviewed the order and should have followed some procedure without violating the principles of natural justice. Full stop. He relied on the decision in
that is, your lordship, AR 1936 Privy Council.
Nazir Ahmad, sir.
Nazir Ahmad?
No, that is Lord Rochi. Oh, Nazir Ahmad, your lordship, I'm sorry.
What is this order that you're reading?
This is a matter relating to service.
No, which is that judgment which you're now reading, sir? This can't be Nazir Ahmed. You're referring to some report, OCR. What is this? What do you have in your hand?
This is OLR, your lordship.
Obviously, Nazir Ahmed is not reported in OLR, sir. What is the decision you're relying on?
Again. That is, your lordship, 2012-555.
Name of the case, sir.
Vishwanath Sethi versus State of Odisha and others.
Relying on Vishwanath Sethi versus State of Orissa.
And others. In sir, WBC number 269.
Citation, sir, please.
2021-1.
2021-1 OLR
555.
555. Full stop. The proposition, although is well settled, that if the statute requires a thing to be done in a certain manner, it has to be done only in that manner and not in any other. In the present case, it is seen that the original order was also passed without following this procedure, this principle. Full stop. In other words, without issuing the statutory period notice, without adhering to the statutory notice period, sale permission was granted. And that is what is sought to be corrected by the collector. In the circumstances, the view of the learned single judge that the collector did no wrong does not require to be interfered with. There is no merit in the present writ appeal. It is dismissed as such.
Item 38.
Short passover, Lordship. A short passover.
Item number 39.
May I please, Your Lordship? In Item 9, there are two writ appeals, Your Lordship, challenging the same common judgment, Your Lordship. Now, Your Lordship, kindly take up the second brief, in which I am the appellant, Your Lordship.
Who's the first appeal?
I am the first. Same order have been challenged in both the appeals, Your Lordship.
All right.
I shall kindly see page number 30. This is a resolution for constituting governing body for the Ayurvedic medical colleges for both private and aided government colleges, Your Lordship. Now, I am coming under category 2C, Your Lordship. I shall kindly see page number 32. 32, they have created some criteria in which the governing body has to be constituted. Now, the entire dispute arose where some of the terminated employees of the college, they have made an application before the director. Now, what the director has done? The director has constituted a governing body without consulting with the principal, who is the ex-official secretary of the institution, Your Lordship. I shall kindly see page number 44. Answer 6, page number 44, Your Lordship. Yes. My Lordship, may kindly see page number 45, para 9. I will read it out, Your Lordship. 5 members to be nominated by the
5 of which paper book?
The second, no, of the I have included in the writ appeal, Your Lordship.
There is 278.
Yes, Your Lordship.
There is no para 9 in page 45, sir.
Second, clause 9, Your Lordship.
Clause 9.
Clause 9. I'm sorry. I beg apology. 5 members to be nominated by the NGO started the college from among its members, from among the persons in the total area interested in Ayurveda education, desirable to be nominated by the concerned NGO in consultation with the collector. Now, the important portion is the next paragraph, Your Lordship. In case any problem for members to be nominated from NGOs, persons having interest in Ayurveda in local can be nominated in the GB. I have answered this one. I shall kindly refer to Annexure 2 again. In Annexure 2, which is the resolution passed by the Health Welfare Department, nowhere it has been stipulated that the recommendation of the collector is required. Now, I shall kindly see the order I am challenging of the Honorable Single Judge. That is at Annexure 15, page 59, Your Lordship. The Honorable Single Judge has referred to earlier order passed in the writ applications preferred by these appellants, Your Lordship. I shall kindly see page 64, page number 4. I will only take 2 minutes, Your Lordship, not more than that. Page 64, internal page 4, Your Lordship. I shall kindly see the paragraph 5. It is borne out from the records that the government framed guideline for constitution of governing bodies of government and private Ayurvedic and homeopathic colleges as per Annexure 2 On 3/11/2007, the government in the Department of Health and Family Welfare, opposite party number 1, constituted the governing body of the college as per Annexure 6. A writ petition was filed by Sarat Kumar Mahanti relating to the constitution of the governing body of private aided Ayurvedic college, which was registered as WPC number 167006. The writ petition was disposed of on 22/2007. It is apposite on the part of this court to take note of the exact order. The order was quoted. I am relying upon page 65, page 5, paragraph 5 of that judgment. In view of the opposite facts, this court feels that the end of justice and equity will be better served if the Secretary Health and Family Welfare Department calls for the file, affords an opportunity of hearing to the petitioner, and passes a reasoned order reading Constitution. The government body and directs accordingly the entire exercise shall be completed within a period of 3 months. Now, this was the order. Master, can you see page number 50? Despite the order of this honorable court, what the Undersecretary has done, he has again validated the governing body which we have challenged. Now, against that order, again application. That is at page number 60, page number 66, Your Lordship. Paragraph 7. Now, ultimately, this honorable court held that at page number 7, the penultimate portion, Your Lordship, since the government did not consider the matter as cited by this court in WPC number 167006/2007, this court sets aside the impugned order passed on 22/2007 by Annexure 10 and directs the government to re-examine the matter as passed by order dated 16/2008 of the Commissioner cum Secretary to the Health and Family Welfare Department and take step afresh in view of the order passed in WPC number 1670/2007. Now, this was the direction, Your Lordship. Now, again, my Lordship, what they have done without consulting me, they have approved the governing body, which was earlier I have challenged. Now, against that order, I have come with only a single judge. What only a single judge is done? My Lordship, kindly see page number 14. Sorry, page number 74, internal page 14.
Yes.
It starts with para 19 in the previous page, para 19.
Yes.
It was very emphatically argued by the learned counsel petitioner that while disposing of the matter, the opposite parties have not given reasonable opportunity of hearing to the parties. But while considering the matter again, after the order dated 26/7/2012 passed by this court in WPC number so-and-so, no opportunity was given to the college or the founding members or members of the governing body for hearing. However, this court takes note of the fact that government has acted as per the order passed by this honorable court in order passed in the first petition. This court has directed an opportunity should be given to the petitioners and reasoned order may be passed. When the petition was disposed of by this court held that the state government did not consider the matter as cited by this court on 20/12/2007 in WPC number so-and-so, and therefore quashed the impugned order dated 22/10/2009 by Annexure 10 and directed to re-examine the matter as passed by order dated 16/2008 of the Commissioner of Secretary to Government, Health and Family Welfare Department and take steps afresh in view of the order passed in WPC number 1670/2007. This is relevant, Your Lordship. Nowhere in the order, this court had directed the petitioner should be reheard in the matter. Now, my Lordship, I am ready to, being the principal and ex officio secretary, I am ready to submit my proposal in terms of the 2005 guidelines, but the opportunity of hearing should be given to me. Why I am saying so, Your Lordship? Even though this court has taken note of the fact that the WPC number 1670/2007 has not been complied with, what this has said, Your Lordship, kindly again see, Your Lordship. That is at page number 4. The next page, para 5. View of said facts, this court feels that ends of justice and equity will be better served if the Secretary, Health and Family Welfare Department calls for the file, affords an opportunity of hearing to the petitioner, and passes a reasoned order.
No, but in the impugned order, just come to page 75.
Yes, Your Lordship.
The operative portion says, hence the authorities, while constituting the governing body, shall not insist on prior consultation with the collector.
I'm obliged, Your Lordship.
That is in your favor.
It's in my favor. I'm not disputing that. My only grievance is the order of the single judge passed in the earlier interpretation has not been completed. My only grievance is let them constitute the governing body. I will submit the proposal.
No, but this is 5 years. What has been happening with that? This institution is running without a governing body.
There is a status quo operation is the earlier governing body is still continuing, Your Lordship, by virtue of the status quo order passed by this honorable court. I am ready to submit proposal, Your Lordship. There is no deny about that. I will abide by the judgment of this honorable court, but the opportunity has to be given to us. That is my only case.
I am appearing for the governing body, which was last constituted in the year 2019. If a Lordship would kindly see an order passed by this dated 13th of September 2019. Kindly see that order. Lord, it's question of a Ayurvedic college receiving granting aid from the government.
Whom are you for, sir?
I am for the governing body members who were nominated and appointed by the government in the year 2019. And that has been stayed in this writ appeal, though this was never subject matter of challenge before the Honorable Single Judge. Kindly see order dated 13th of September 2019.
No, but as a result, what will happen? The single judge has asked for the exercise to be reconducted.
Right, Lord. That's the order to constitute the governing body. I just wanted to tell Your Lordship, what is the government's guideline for constitution of a governing body? There are two types of colleges, C1 and C2. C1 colleges are category of colleges which are not receiving grant from the government, and their manner of constituting the governing body in terms of C1 guideline. Now, C2 types of colleges who are receiving grant from the government, and their constitution of governing body procedure is prescribed therein. Now, they tried to contend before the Honorable Single Judge that we are category C1, therefore government has no business to formulate the governing body for our types of colleges. That's their contention before the Honorable Single Judge. Now, the Honorable Single Judge has been pleased to conclude that no, you have received grant of 40 lakhs somewhat during 2002-3. Now, you are a category of colleges coming in category 2, C2. And that is how government, in terms of the guideline, has justifiably constituted this governing body. And that governing body again has been stayed in the writ appeal, though it was never subject matter of challenge. Now, that's the entire thing is a mess now, the governing body, because everything is being stayed here. Government is, despite formation of governing bodies for management of this Ayurvedic.
No, there's only one small relief granted saying don't insist on to the collector.
Right, my lord.
Approve the collector.
Right, my lord. That is because in view of the guideline itself.
Yes.
The question of they initially tried to challenge the guideline. In the third set of writ petition, the Honorable Single Judge said that earlier two writ petitions, you never challenge the guideline and only challenge the governing body. Now you are not, it is not open to challenge the guideline. That is how it is concluded, relying upon the principle of res judicata. Question of challenging the guideline is concluded that way. And question of constituting the governing body, Honorable Single Judge has been pleased to hold in terms of the guideline itself. So exercise is to be completed in terms of the judgment.
Can I submit, Your Lordship? I am ready to abide. But when I said I am never challenging, I am not disputing it. I will submit proposal in terms of the C2 guidelines. I am not against that. I'll submit a proposal. But it has to be worked out in the way this Honorable Court has directed. They've never done that. That is my only case. I will submit proposal in terms of the resolution.
C2 doesn't permit to give them proposal.
This Honorable Court has directed. My entire thrust of the argument is this Honorable Court has directed to give me opportunity of hearing.
Page 36 can be similar. C2 doesn't.
I've already shown that. I'm not disputing that.
1 second. You are giving proposal page C2 page 36 can be similar. This is what is binding the parties. And everything is to be done in terms of the C2 guideline. Page 36, government's guideline of 2005.
No, page 36 is a copy of a letter dated 12/9/2007.
Second prediction.
Read up in 77 of 2017. 77 of that same guideline.
Same guideline. It's in my
same guideline. Finally, check up this read up in 277.
Page 33 in my brief, Your Lordship. Page 33. Page 33.
Kindly see this one. Whatever is provided here, that should be done in terms of this guideline.
Nobody is disputing that.
That's right.
I'm not disputing that.
End of the matter.
I'm only submitting because we are the trust members, finding members, as this Honorable Court directed to give proposal in terms of this resolution, and opportunity of hearing has to be given to us as the collector has flouted the order. And nothing else to say. I'll submit the proposal.
He's saying you don't have to submit any proposal.
Yes.
Now, matter is submitted, Your Lordship. Because why I'm saying
Let us read it together, Milan. Let us read it together. Everything will be clarified. The private and homeopathy colleges availed granting aid from the state government, central government under various schemes shall be constituted governing body of the college in the following manner. Now the names are provided here. Constitution of governing body in the above manner shall be furnished through Director so-and-so Odisha for approval of the government. tenure of the governing body shall be 3 years from the date of approval by the government. Any member may resign from the governing body by sending a letter of resignation, so and so, my lord. I don't, my learned friend, point out anything.
Their term has already expired. Even if we will see this, my lordship, the term has already expired. The term was for 3 years.
Because of the stay order.
Stay order, the beneficiary.
So start afresh, sir.
Yes, Lord, of course. In terms of this C2, they would.
All right.
I'm already spoke, my lordship.
What is not correct? You say the challenge in the present writ appeals is to a common order, is it?
Yes, your lordship.
Common order. Common order dated 18 July 2017, passed by a single judge, disposing of writ petition civil 5336 and 71 of 2009. Filed by the present appellants. So the subject matter of challenge was to resolutions of the Health and Family Welfare Department, Government of Orissa, framing guidelines regarding constitution of governing body of Ayurvedic Medical College State, and subsequent orders dated 19th February 2013 and 2nd March 2013 of the government, constituting such governing bodies in the two colleges in question. That is there are two different colleges, right?
One college. It's the same college, your lordship.
One college.
Of the Sri Nrsimhanath Ayurveda College and Research Institute at P.O. Paikmal, District Bargat. Paragraph. While declining to the admitted position is that the said private educational body, private Ayurveda College and Research Institute falls in category C2. That is, it is a private body receiving grant and aid from the government. Full stop. The learned single judge has declined to interfere with the guidelines. Full stop. It has been noted in the impugned order that that was the second round of litigation, with earlier writ petitions having been disposed of, with directions to the government to constitute the governing body after giving the petitioners an opportunity of being heard. Full stop. While declining to interfere with the decision of the government, the learned single judge has accepted the plea of the present appellants that while constituting the governing body, the government, open quotation, shall not insist on prior consultation with the collector as far as nominations of such 5 members who are to be nominated by the concerned NGO/trust from amongst its members, are concerned. Full stop. Paragraph. While issuing notice in the present writ appeals on 13th September 2019, this court had directed status quo to be maintained in respect of the functioning of the governing body. Full stop. A notification issued in the meanwhile on 19th August 2019 by the Health and Family Welfare Department, constituting the governing bodies, was also directed to be kept in abeyance by this court. Full stop. That stay order has continued for over 3 years now. Full stop. As a result, the existing governing body, as on the date of the interim order, continued, and many of the members have completed their respective terms. Full stop. Paragraph. A fresh exercise. It's obvious that any fresh exercise of constituting the governing body in these two private educational in the said private educational Ayurvedic institution has to abide by the guidelines already issued by the government for that purpose. Full stop. Paragraph. Counsel for the appellants submitted that they would submit fresh proposals, which would then be considered by the government in accordance with the guidelines. Full stop. Mr. P.K. Rathal, appearing for the erstwhile governing body, submits that there may not be any need for any fresh proposal as such to be submitted by the institute. Full stop. Be that as it may, it appears that it is agreed by all parties that the governing guidelines on the issue have to be scrupulously adhered to by all parties, including the government. Full stop. This would include, as far as the members to be nominated on behalf of the NGOs or trusts, with there being no prior consultation being insisted upon with the collector. Full stop. While vacating the status quo order, the court directs that the fresh exercise, strictly in terms of the guidelines, be undertaken forthwith and be completed within a period of 2 months from today. Full stop. The writ appeals are accordingly disposed of.
Item 40.
My Lordship, with regard to opportunity of hearing, why I'm saying so, the college will perform, my Lordship, against the page 32. It has to be performed to the college, Your Lordship. The governing body has to be constituted by the college itself. That's the guideline says.
That doesn't say.
That the guideline says. Page 32.
Third line of litigation again. Look,
I'm ready to give the.
No. If at all you have any grievance after its constitution, you can raise it. But at this stage again, it can't be.
But when this court has already did,
there has to be anyway a consultation from both sides.
Look, there is
if they have to be given a hearing, then how will you give them a hearing?
If that will not be case, then how the founder trust will nominate the names? That has to be consulted, Your Lordship.
Honorable single judge has clearly held that there is no requirement of hearing.
No, but it has to be a consultative exercise.
Correct. Consultation is also not required. Kindly see.
Kindly see page 32.
What was the meaning of the first order of the single judge then? Maybe actual physical hearing is not necessary.
Yes.
But you can't ignore the college itself.
Ignoring not. Kindly see that guideline. Kindly see that C2. It has to be within framework of C2.
C2 has to be read with C1, the first paragraph. You cannot read it alone. Kindly see C.
C2, man. Yeah,
C2 has to be read with C1. Page 32.
You complete, then I'll say it can't be one by one.
It cannot be read through isolation.
You complete, then I'll have my submission. Page 36 of my brief, I am addressing a lot. Kindly see. No amount of, it's a say, constitution of the governing body in the above manner. Kindly see that. Page 36. Lord, he is trying to rewrite this now.
No.
He is trying to rewrite all, expanding the scope so that it will.
No. But there is a nominee, for instance. Yes. There is a nominee of the vice chancellor of the affiliating university.
Yes. They will be issued later and they will nominate.
What about with regard to 7?
Kindly see, my lord.
7.
7.
Yes, 7. How did we done?
Propose their names. What is the question of consultation?
Yes, the NGO trust.
So they should propose the names.
Yes, that is
trust. For who say no? I don't say no.
Without hearing us, how can they pass immediate order?
Here we are.
That is how that
is being hard.
Sir, 1 minute, sir. That is my entire case. Without consulting us, they have given names. The collector has done what the collector has done. Any imminent.
Or it is clarified that while undertaking the fresh exercise, strictly adhering to the guidelines.
Yes.
The categories, the members proposed under category 2(7) by the 2(6) and 2(7).
Yes.
By the institution will be taken into account, and the exercise will be a consultative exercise. I think that will.
I'm grateful. I'm grateful.
For 40.
Item 40, Your Lordship, no instructions.
No instructions discussed.
Item 42.
None appears dismissed.
Item number 43.
Same.
Item number 44.
4, 5, all.
All there are batch of cases.
Item 45.
Yeah, up to 45.
Item number 46.
None appears dismissed.
46 and there.
Not
in this case.
46 to 50.
55, my lord.
55. Tell us.
In this case, my lord, I have challenged under Annexure 9, passed by the Honorable Single Judge. And before that, just I am placing, my lord, Your Lordship kindly have a glance Annexure 1. On the basis of Annexure 1, the London Tahsildar issued under Annexure 2, my lord. Annexure 1, Your Lordship kindly have a glance. Division bench has directed for issuance of ROR. On the basis of that, my lord, ROR is issued under Annexure 2. And on the basis of Annexure 2, my lord, Annexure 3, I paid rent of the concerned land, man. And in this case, what happened, my lord? This is third round litigation. After third round litigation, my lord, Your Lordship have a glance Annexure 4. Annexure 4 to the single judge, the same single judge, alone single judge has passed, allowed my writ application, directing the Tahsildar to file a fresh appeal, my lord. In the fresh appeal, Your Lordship will find it from the record, my lord. In the fresh appeal, no sanction was passed by the Tahsildar. Without sanction order, appeal was preferred. And again, I challenged that order under Annexure 5, my lord. Under Annexure, thereafter Annexure 5, they have preferred appeal. In the appeal, my lord, Your Lordship have a glance orders per year.
7/2/2017.
2015. Earlier, Annexure 4 was 2015. And Your Lordship will find from the Annexure 5, this is appeal in the year 2014. They have annexed.
But disposed of in 2017, sir.
Last order 2017, my lord.
7/2/2017.
Yes, Annexure 9 is 2017.
That is the single judge's order, sir.
Yes, my lord.
We are now on the sub-collector's order.
Sub-collector order, Annexure, my lord.
7,
my lord. Your Lordship will find Annexure 7, why I am challenging. The single judge has not categorically reflected in the order sheet that the same Tahsildar, while he was Tahsildar, he passed the order. And he promoted to the post of sub-collector. He again heard the matter and disposed of the appeal. How he can, my lord, pass the order? 1987 Supreme Court, page 4544, clearly reflects that his own cause he cannot pass order. And before this honorable court also, my lord has passed order that he cannot pass order for his own cause. Your Lordship will have a glance Annexure 6.
No. Who was the sub-collector? Kamakya Nagar. What is his name?
My lord.
This 7th February 2017.
Yes, my lord.
What's the name of this official?
Just I am placing Annexure 6. Your Lordship may kindly glance. Annexure 6, which is notice issued by the sub-collector. The same signature, Your Lordship will be reflected under Annexure, my lord,
4.
Annexure 7. The order passed.
No.
Same signature, the same and Your Lordship will corresponding to Annexure 8, the permission passed by the Tahsildar, the same Tahsildar has applied for permission granted from the collector. which this annexure 8 is not, which is totally palpably wrong. And without application of mine, the sub-collector has passed the order. And again, on the basis of annexure 5, my lord, I preferred appeal.
So what is the date of the additional Tahsildar's order and where is that order?
Additional Tahsildar order, my lord, the annexure, my lord, page 38, this sub-collector order, annexure.
Sir, please, we are not asking about sub-collector's order.
Yes, my lord.
The order in appeal before the sub-collector was by which authority?
Appeal, my lord, annexure 5. Annexure 5.
Additional Tahsildar order ta kete kon?
No, annexure 5 is the appeal memo, sir.
My lord.
Which is the order under appeal, sir. Before the sub-collector, there's an order under appeal.
My lord, read petition, in the read petition, there is your lordship, I will last order. This honorable court has directed to call for the entire order from the court below.
No, you will not file it, we will produce.
So you have to produce. If you are saying it is the same authority who has passed the order under appeal, you have to show from that order that the signature is the same.
Because your lordship, annexure 6 and 7, same Tahsildar promoted to the post of sub-collector, annexure 8, the same signature that is reflected from the order sheet itself. Annexure, my lord,
he's applied for permission. Did he pass the order himself? Did the Tahsildar pass that order?
While he was Tahsildar, the same Tahsildar, same person promoted to the post of sub-collector. He passed the order under annexure 8, annexure 7.
No. Annexure 7, gentlemen passed the order, correct? That order at annexure 7 has
passed by the sub-collector.
Correct, sir.
Yes,
it reviewed a certain order, correct?
Yes.
Which order was reviewed by that appellate order? Where is that order which was under appeal?
Order annexed, that has not been.
That is not annexed, but annexure 8
unless you show that order was passed by the very same gentleman.
He is relying on annexure 8. He is relying on annexure 8, which is only a requisition to the collector.
That's right. Annexure 8 is simply a request to file an appeal.
He might have requested
same person
yes,
highly
maybe.
Tahsildar. He preferred.
No.
Preferring appeal is one thing, sir. Did he pass that order is the question.
Passed.
Against which he was seeking permission to appeal. Did he pass the order?
Well, I may granted.
No. We are not adjourning like this, sir. We are certainly not adjourning.
Another thing is that your lordship may see, these facts are not discussed in the impugned order even. These facts, what he is now submitting in this appellate stage, that is not discussed in the impugned order.
Your lordship, kindly have glanced the.
Your lordship may kindly see page 50.
From the
page 50 of the
decision passed by the this honorable court.
There is a forgery signature. Page 50.
Maybe. Maybe forgery. But annexure 1, your lordship,
if you say that, maybe then I have nothing
let
to
me
say.
finish my argument. Thereafter, you will argue.
Forgery initiates everything, sir.
Forgery, that's the end of the matter. Annexure 1. Since my forefathers acquired the land, poor fellows, and they acquired the land since more than 60 years, and they have acquired on the basis of acquisition under section 4, 6, and 8 of the OPLA Act. And your lordship will find from the annexure 1. They have not challenged. Annexure 1 has passed by this honorable court, division bench of the honorable court. In spite of that, they have not challenged annexure 1. And annexure 2 was issued in my favor. And till then, they have not challenged. Thereafter, the learned Tahsildar and passed
in your writ appeal, where have you taken this point? Let us see that.
Malad, I have taken stand.
What have you taken? Let us see.
My writ petition.
Writ appeal, sir.
Writ appeal, page 9, para 16. That it is further submitted here that where illegality and impropriety in order of settlement of fraud or misrepresentation has been committed, their matter is authorized, and Tahsildar can accord approval from the collector to decide the same, but without any approval order from the collector, filed the appeal by authorizing the additional Tahsildar is totally bad in law.
No, this is very different from the point you are now trying to argue, sir.
Next I am just placing para 20. That it is out, para 20, page 10. That it is out of place to mention here that without notice to the applicant, hurriedly disposed of the same on the date fixed for appearance, and as per order sheet, it is clearly reflected therein that matter has been noticed on 6/1/17 and directed to be called for LCR.
This is not the point
which you are
not making.
On the same
point you're making the appeal
dealt with.
This honorable court directed for preferred appeal to the Tahsildar. Tahsildar preferred appeal. before the sub-collector. Sub-collector issued notice to me. Without notice, I have not received the notice. On the same day, he was directed to be posted on 7/2/17. On the
some other point now.
Without hearing him.
Now you have gone to some other point.
Thereafter, your lordship will find from the I have also annexed. Thereafter, your lordship will find that against the order of the Lord sub-collector, Sad is the file WC1, the honorable challenge the maintainability on the question of a limitation as notice and properly served without any approval. Appeal is bad in law. The same court file he was holding Tahsildar issued ROR, 26, 26, page 12. Page 12, 26. That against the order of the sub-collectors dated 7/2/2017, the appellant had filed WPC number so and so before this honorable court, challenging the maintainability on the question of a limitation as notice was not properly served. Without any approval, appeal is bad in law. The same court, while he was holding Tahsildar, issued ROR, and when he promoted to the post of sub-collector, entered the appeal, had and passed the order, and further, against dead person, notice was sufficient, and basing on the above, the honorable single judge, without application of mind and without taking note earlier, order was disallowed and prayer of the appellant was passed. And then, apart from this, my lord, there are 14 appeals, my lord. 10 appeals before this honorable court, and another 4 appeals are there. 14 cases, 10 cases he dismissed the writ petition, and 4 cases allowed my writ petition, directing the Tahsildar to rehearing the matter. Now, another 4 appeals are also pending before this honorable court.
Mr.
How, my lord?
Yes, ma'am. If you read this annexure 8, page 41, let's read that first paragraph. He's not able to, I think, correctly present the case. Just read that. I am to bring to your notice.
Yes, 14 number of NSA by then Tahsildar Kamakanagar.
That is not permission, my lord.
Since on the subsequent inquiry conducted by me, it was ascertained that the beneficiary is not at all landless person, and the settled land is a valuable piece of government land coming within adjacent to the proposed OTPCL plant. It was accordingly decided to file appeal case against sub-collector.
So basically, that the appeal is now against orders settling
the plan
plots. So that order settling was passed long ago.
Long ago.
Long man.
That is not an. I will draw your lordship's attention to page 47.
He is not the same person.
No. It is long thereafter.
Okay.
And page 47 may kindly be seen. Impugned order, page 47 of the writ.
But he conducted an inquiry.
Yes. Page 47. Thus, coming to consider the merit of the case, this is the view of the Honorable Single Judge. The appellate court has observed the following irregularities. 1, 2, 3, 4. Next page may kindly be gone to para 17, page 48. The forged signature of the Tahsildar on the order sheet shows that the valuable government land is settled illegally in order to grab compensation. Then I will take your lordships to next page. Page 50. For the serious allegations involving a doubt in the manner of the land got settled, doubt in the signature of the Tahsildar involved therein, the competency of the person settling the huge portion of the government land when the petitioners claiming to be homelandless agricultural land having been settled, involvement of forged signature of the Tahsildar functioning then and the land involved. So, your lords may kindly, they want to take compensation from a company and they got the land settled in their favor by the then Tahsildar by forging the signature of it. That is the view of the sub-collector confirmed by the Honorable Single Judge. If there is a case of forgery, I think there is less scope for the Honorable Appellate Authority to interfere with the impugned order because there is a clear finding. He has to get over this finding by both the courts below, including the sub-collector and the inquiry report and the Honorable Single Judge, that the signature of the Tahsildar has been forged to get benefit in respect of a huge patch of government land.
Now, my lord, they are saying, no, here they have mentioned that.
Now means the sub-collector has found
earlier 2 recap by the honorable court. In the division bench, another is single bench. But this same single judge has.
So,
allow no writ application. Annex 4, my lord. This same single judge,
when we got this, when the sub-collector got the information.
And appeal is not maintainable. After all, appeal is not maintainable. Your Lordship can have a glance the annexure decision passed by the
Really, you are settling the land as a landless person under section 7B. That is not appeal is not maintainable. So that order of the Tahsildar, according to you, is final and conclusive. It is not challenged. It cannot be challenged. If you have application of fraud, even the government will sit silent because there is an honorable High Court. By that time, the honorable High Court was not appraised about the.
Your Lordship can have a glance the decision passed by the Honorable Court 86/1998 CLT page 853.
See, you don't produce photocopies of judgments. You open a book at your end, you start reading, and you want us to read. How are we supposed to read what you're reading, sir?
Well, permission has not been accorded by Tahsildar without filing. Without permission,
I have to seriously consider whether my English speaking is correct or not.
No,
whenever I ask counsel a question, he doesn't answer the question at all. He starts arguing something else.
I may be giving chat one file because there are two sets of appeal.
We are not adjourning.
Four appeals are
we are not adjourning. You try whatever you want, you try. We are not adjourning. Short of adjournment, you do whatever you want.
Tomorrow, I will.
Sir, again, my English is, I think, very poor. I'm repeatedly saying there will be no adjournment.
Because poor fellows are there.
So they were always there, sir. They were there for 30 years now.
Patch of land in Kamakhanagar town. Your Lordship can imagine.
No, not
and you are saying that landless persons and landless persons. You are getting land acquisition money, not for your homestead.
Much before I have acquired the land. And I have.
If you are landless, so you require land to take your sector. Not that the compensation to get from the, and the binding is that there is the signature of the Tahsildar is
if anything is there, why they have not challenged one? Annexure 1, why they have not challenged?
That is why the challenge to that only has resulted in all of this. They made an inquiry and found that
they set up
fraud. Yes, he is correct in saying after so many years, this fact came to light and the sub-collector then moved for it. But so far as the findings of the sub-collector, which is confirmed by the Honorable Single Judge, the conscious finding that there is a case of forgery. That is what I want to submit to your Lordships.
Let him file an affidavit that whether I have forged or not.
That is there in the order itself. What affidavit more you require?
That I have a challenge before the Honorable Court. That I have not committed any fraud. For that reason, the Learned Single Judge committed a mistake by entertaining the writ petition, entertaining the appeal of the parties.
Right.
Appeal, your Lordship have a glance. Appeal, as for Annexure 7, your Lordship kindly have a glance. Just Annexure 8.
I think this is similar to those. There was a whole series of matters which went to the Supreme and the fraud will unravel everything.
Yes. Brindavan Sharma case.
Brindavan Sharma.
Earlier writ application, the Learned Single Judge has not whispered a single word that I have committed any fraud.
At that time, this was not discovered. Subsequently, on inquiry, it was discovered.
Neither they have filed any counter, nor they have filed any document to show that I have committed fraud. If anything, any scrap of paper they would have filed that I have committed fraud, then I will be obliged. Not a single paper they have filed, my lord. Your Lordship have a glance and Annexure 8.
Yes.
This is not a proper forum. Dispose of, my lord, Learned Single Judge dispose of in the year 2016 and the appeal has been filed in the year 2015. That they have reflected. And permission is in the year 2015. How it has to be? These are poor fellows. How they will survive only without, they are the only property, my lord.
Which is already acquired by a company and you are now claiming compensation.
My lord, till now we have cultivated in the land and we are staying there.
So you can imagine that what is the extent of land which you are cultivating and you are claiming yourself to be poor persons.
2 acres.
You are contradicting yourself, sir.
My lord?
Valuable piece of land which you are cultivating for so many years and you claim yourself to be landless and poor.
When the notification was issued, thereafter such a plea was taken. Before that, they would not have taken any plea that acquired by the OPTCL.
Yes.
Only I pray, my lord, I may be permitted to 1 week time so that I will file that judgment as your lordship is asking.
We are not asking anything, sir. You want to cite a judgment, you produce the judgment. And
judgment, my lord,
this is for the third time I'm repeating.
86 clearly says unless and until
this is the third time I'm repeating, there will be no adjournment.
My lord, your lordship may kindly glance 86 passed by the Honorable Court, Division Bench of the Honorable Court.
So from here to glance there is very difficult. So you glance yourself. And you tell us.
Unless and until, my lord, the permission is not granted, permission is not in the proper form, the appeal cannot be entertainable.
All right.
Your lordship, I am just placing the decision passed by the Honorable Court in 86.
I don't know which permission he is seeking. Sub-collector will take, it is inter se permission. Collector is also before your lordship. We are jointly fighting, the entire district administration
permission is not necessary.
Lordship. And if there is no permission, how the collector himself is also a party to the writ petition.
From middle. What citation, sir?
My lord,
you're passing a page which starts in the middle like this.
This portion, my lord.
Which portion of what?
That is there that has been clearly reflected that permission is required for filing appeal, my lord. Your lordship, top of the decision, your lordship. Where appeal has to be filed, there must be requirement of law.
His only contention is now confined to the fact that for filing of the appeal, inter se permission from the government authority has not been obtained. But fact remains, the appeal was adjudicated in accordance with law, exhaustive judgment was passed, confirmed by the Honorable Single Judge. And so far as permission is concerned, all the authorities are before your lordship, and we confirm that with due permission, this appeal was filed. If your lordship will see annexure 8, page 40.
Just one thing to para 3 of the writ appeal. Actually, has he urged this in the writ petition? Is what we have to see. He says this same additional Tahsildar had issued the ROR. Is that right? Let's see what he says in the writ petition. Did he take such a plea in the writ petition?
And that permission part,
I have taken
my learned friend is what he is saying regarding permission part. If your lordship will see page 44, there was an permission.
No. Did the same person issue the ROR, which he's seeking cancellation of?
Additional Tahsildar has moved instead of head clerk because the challenge was that the same person cannot file the appeal. That is why additional. That is page 54 of Annexure 9.
No. But who passed the original order? The ROR was granted by whom?
ROR was granted by the then Tahsildar. Thereafter, several.
No. Is that same person sitting as sub-collector?
No, it cannot be. That is not his case in the writ petition nor before the.
They did. Yes, I have in that case. I have
No. That is not there in the impugned order.
Where was this ROR issued?
ROR issued in the year 2012, my lord. Under Annexure 1, order was passed. Thereafter, Annexure 2, your lordship may kindly have a glance, page 21. Annexure
The
11.
signature. If you come to the writ petition, page 17.
Yes, ma'am.
The writ petition, page 17.
Yes, my lord. It is not there.
The Tahsildar Kamakhya Nagar.
Yes, Tahsildar Kamakhya Nagar.
No, just see his signature.
Signature. Now, the order sheet is also here, annexed to the appeal memo.
Same person, my lord. Same person, Tahsildar, and he was promoted to the post of sub-collector. He allowed dismissed my case.
This Tahsildar's signature and
same, my lord.
Sub-collector same.
Annexure, page 38, your lordship will find same signature in 39 and 40, and same signature in Annexure 8, page 41.
Back to sub-collector.
Page 38.
Page 38.
Of the appeal memo?
No, appeal memo. Page 38.
The same signatures.
If your lordship will have on bare perusal of the impugned order, this ground is not discussed. That the person, the officer who has settled the land in favor of the petitioner.
It is obvious. That's why in the writ appeal is made it. See, in para 3, you will find of the writ appeal, he has taken it.
Yes, para 3 he has discussed. He has stated.
Yes.
Issuance of ROR and passing the order under section 7B of the OPLE Act, settling the land, we have to see that whether he is the same person who has passed the order settling the land in favor of the petitioner under the OPLE Act.
So in that fresh appeal, because this is the third round, sir, in the second round, there was an order dated 15 September 2016.
Yes, my lord.
While allowing the writ petition, it said it shall not preclude the state authority file appeal afresh. In the event fresh appeals are filed, the same shall be considered and disposed of on its own merit and in accordance with law, taking into consideration first delay. So delay was also to be taken into account in the appeal.
And consequentially, the appeals were preferred before the sub-collector by the additional Tahsildar.
No, but while considering that, the limitation is also to be considered.
That is not the point raised by the petitioner so far as limitation is concerned, my lord.
Perhaps you have not gone through the file. You've gone through the file.
Impugned order, there is no such.
See, the same problem is, while considering the appeal, not to notice that the same authority had issued the
same sub-collector had issued,
as Tahsildar.
No,
he was the same Tahsildar who issued the ROR.
Subject to your lordship's permission.
That ROR is issued pursuant to order of this court.
ROR was issued pursuant to the order of settling the land in favor of the.
No. There was an order by this court in 2012.
Sir.
That was the first round of litigation.
Yes, my Lord Justice Gopal Gowda. Yes.
Therefore, the entitlement of the petitioner has to be recorded in the ROR. We therefore directed Tahsildar to issue the necessary documents.
Yes.
This Tahsildar who did that is the same person who is now setting it aside in appeal, sir. The very same person. That's the difficulty. So this point regarding your permission to file appeal will no longer be valid because in the second round, this court granted permission to file the appeal.
Exactly, my lord.
So once this court grants permission to file an appeal, all this is of no use. That second round of litigation, the court permitted. So this point will not hold good, but the point that
permission was granted.
So the only point that survives is the same person passed the order. That's the only point that survives. So we can send it back to the sub-collector to pass a fresh order. We'll make it time bound, sir. The present, put all the writ appeals together. These writ appeals are directed against the common order dated 26 July 2017, passed by the learned single judge dismissing the writ appeals, writ petitions, civil numbers, just take all the numbers from the impugned order of 2017 filed by the present appellants. Paragraph. Before the learned single judge, the above writ petitions were the third round of litigation. In proceedings emanating from the Orissa Public Land Encroachment Act,
OPLE Act,
bracket OPLE Act, involving lands in Kamakya Nagar, stated to be under occupation of the present appellants. Each of the present appellants claimed that he was a poor and landless person belonging to the BPL category and applied to the Tahsildar Kamakya Nagar for settling land on the basis of being in possession for more than 50 years and also taking into consideration the possession of the predecessor in interest. Paragraph. It that the Tahsildar at the relevant point in time issued orders settling the corresponding lands, parcels of land in favor of each of the appellants, but did not issue the record of rights, bracket ROR, This prompted the appellants in the first round of litigation to file writ petitions in this court. First of one such writ petition was Writ Petition Civil 12401 of 2012, which was disposed of by a division bench of this court by an order 30th July 2012. Directing the Tahsildar, Kamakya Nagar, to record the ROR in favor of the concerned petitioner within 4 weeks from the date of the receipt of the order. Paragraph. Pursuant thereto, the then Tahsildar Kamakya Nagar issued the ROR on, what is the date? 2010, is it? ODI, I think it is. Has been 2015 or so. It appears that thereafter, an appeal was filed before the Sub-Collector Kamakya Nagar by the head clerk in the office of the Tahsildar. Full stop. The said appeal was admitted by the Sub-Collector and a show cause notice was issued to each of the appellants. By registering the appeal as encroachment appeal cases. One of the pleas taken by the present appellants was that under Section 12 of the OPLE Act, neither the Tahsildar nor his subordinate staff, including the head clerk, was authorized to issue such an appeal after a lapse of 2 years. Full stop. This prompted each of the petitioners to file a second round of writ petitions. One such writ petition was Writ Petition Civil 12253 of 2015. Full stop. This court disposed of the said writ petition on 15th September 2016. Full stop. The operative portion of the said order reads as under. Take from page 8 of Writ Appeal 295 2017, para 15, that quoted portion. Consequently, while allowing all the writ petitions, this court observes that the allowing the writ petition shall not preclude the state authority to file appeal afresh. Paragraph. Pursuant to the above order, a fresh appeal came to be filed, which was allowed by the sub-collector on 7th February 2017, with a direction to the Tahsildar Kamakya Nagar to restore the suit land to the government khata immediately. Full stop. As many as 17 grounds were set out So 17 different irregularities were set out, which made the land in favor of the writ petitions. petitioners, writ petitioners, unsustainable in law. One such ground was the purported open quotation forged signature of the Tahsildar on the order sheet, unquote. There's also a reference to a field inquiry undertaken by the Tahsildar Kamakenagar. Paragraph. It was the above order of the sub-collector dated 7/2/2017 which was challenged by the present appellants before the learned single judge in the writ petitions in question, which have come to be dismissed by the impugned order dated 26 July 2017. This court has heard the submissions of learned counsel for the parties. In para 3 of the writ appeal, it is prominently indicated that the very same Tahsildar who recorded the ROR in favor of the present appellants was subsequently promoted as sub-collector. And it is that very same person who has now, who passed the orders in appeal on 7/2/2017, allowing the appeals in favor of the state. So in other words, the same authority who recorded the RORs subsequently exercised the appellate power, cancelling those RORs and the orders which led to the making of the said RORs. Stop. Paragraph. The court has perused the ROR, which is enclosed as Annexure 2 to the writ appeal, which is signed, full stop, the said ROR, the signature of the Tahsildar Kamakenagar on the said ROR is identical to the signature of the sub-collector Kamakenagar in the appellate order dated 7/2/2017. So therefore, there is no manner of doubt that it is the same person who has not only issued the initial ROR pursuant to the order dated 30th July 2012 of this court in writ petition civil 12400 of 2012 and batch, but the same but has subsequently sat in appeal and allowed the appeal of the state, requiring reversal of the said ROR. Full stop. Added to this is the fact that the same person, by a note dated 7th October 2015, had written to the collector and district magistrate, then Canal, for permission to substitute the appellant as additional Tahsildar instead of head clerk. So in that note, he mentions how he had himself conducted the subsequent inquiry in which he ascertained that, open quotation, the beneficiaries are not all landless persons and the settled land is a valuable piece of government land. ... unquote. This was one more reason why this person, having initially granted the ROR in favor of the appellants, and then having conducted the subsequent inquiry, as Tahsildar, ought not to have dealt with the appeals when he came to be promoted as sub-collector. Stop. Is the same person now continuing as sub-collector?
May not be, ought not to be.
No, man.
He's not.
Must have been transferred.
He has been promoted ADM.
ADM. I hope there's no further appeal and he doesn't against it as ADM and decide that appeal.
No, your lordship can direct.
Yeah.
Even I can suggest your lordship that your lordship can direct the collector to hear these appeals afresh.
How?
Huh?
How collector?
How the
subcollector. There is a forum. Revision forum is
the
there.
court is now informed that
it has to be existed.
The concerned person is no longer the sub-collector, having been further promoted as additional district magistrate, bracket ADM. Full stop. In that view of the matter, while setting aside, full stop, it is seen that the learned single judge did not take into account the above factor while affirming the order of the sub-collector in appeal. Full stop. In the above circumstances, while setting aside the impugned judgment dated 26 July 2017, the learned single judge, and correspondingly the order dated 7/2/2017 of the sub-collector, the court remands the appeals to the file of the sub-collector Kamakinagar for being decided afresh in accordance with law after hearing the parties. Paragraph. It is made clear that it will not be open to the present appellants to raise the point regarding maintainability of such appeal in view of the express permission granted by this court in its order dated 15 September 2016 in the second round of litigation, permitting the state to file such appeals. Full stop. In other words, it will not be open to the appellants to contend that there is no authorization to file such appeals. Paragraph. Considering that the matter has been pending for long, it is directed that the said appeals will now be listed before the sub-collector Kamakinagar on 5th December 2022. Full stop. Since each of the appellants knows what the case against them is, as set out in the order dated 7/2/2017, bracket, which has been set aside by this court today, bracket. It will be open to each of the appellants to file their detailed submissions in respect of each of alleged irregularity in a note to be placed before the sub-collector on or before 30th November 2022. It will be open to the state to file a note in reply thereto before 5th December 2022. Full stop. No further time will be granted for that purpose. The sub-collector will proceed to hear the appeals on merits and dispose them in accordance with law within a period of 2 months thereafter.
The appellants may be directed to produce the order before the sub-collector.
For this purpose, the downloaded copy of this order will be produced before the sub-collector
by the
Kamakinagar by the appellants
for compliance.
For compliance on 14th November 2020. The appeals are accordingly disposed of in the above terms.
Up to item number 55.
Yeah.
Same matter.
So 55. 55. Up to
55. Right.
Utility list item number 56.
56, my lord. On behalf of Mr. S.K. Mishra, he is ill today. He requested me to pray before a lordship for a short adjournment.
What is the delay? What's the matter about?
My lord, here what has happened, my lord. This petitioner was engaged as a PET in the matrix SIPET scale of pay. But while extending him to RSCP benefits, his scale of pay has been considered as ISCP. On the taking note of his scale of pay as ISCP scale of pay, this RSCP benefit has been extended to him. Thereafter, my lord, a recovery notice has been issued. Challenging that recovery, my lord, he has before your lordship.
His initial appointment was again a metric shipment scale of pay.
Relief sought has already been granted as per rules. What is that?
This some page is missing. Annexure 5 he has challenged, my lord. And also delay part is also there, my lord. A petition for condonation.
Delay is some 17 days.
My lord.
Nothing much. I know. So they've left out one whole. Yeah, they've left out the whole thing. One whole page has been left out. Delay is condoned. The counsel for the appellant stated to be unwell today. January 19th.
Weekly list item 57.
57 last no instruction.
No instructions dismissed.
Item number 58.
My lord, this is a second round of litigation. My lord, that pursuant to that Madhuri Patil case, in accordance with that,
adoptive.
No adoption. Here no question of adoption. It is only question is the Pano Hindu or Pano Christian. But normally Panos, Panos, those who beats the drum and other, they are scheduled caste. So, my lord, while reading the brief, I recollect that he a conclusion that since his name is Michael Naik, so it denotes to a name of a Christian. So that is why he is a Christian. And on the basis of all assumption and presumption, the order has been passed, ignoring the evidence and everything. My lordship, here I may remind your lordship, A.R. Rahman, the musician, who is a Hindu, he is named as A.R. Rahman.
Not named as, he converted.
So, he is not converted.
No, he has
not
converted.
Yes. He is not converted.
No, he has converted.
Because he was he was treated under a Muslim man. That is why.
No. He converted.
Whatever that means. But in the conversion also cannot be that also. But here what has happened, the case is not like that. But here your lordship will find that my lord, in the second round, the evidence was adduced. All the documents as per the direction of the division bench of this honorable court led by the then Honorable Chief Justice Gopal Gowda. My lord, I may draw your lordship's attention to that judgment. My lord, lordship, kindly see. Give that judgment. हाँ Paragraph 6 of the judgment is relevant.
Why don't we read the impugned order, sir?
My lord, I'm
Page 21.
My lord, before that, only thing I may draw your lordship's attention, kindly see the order of first instance that dated 10/10/2017, passed in the writ appeal first. In the
Yes,
my lord.
Then let's stay order.
Yes. Lordship, kindly see in the writ petition at the first instance, my lord, the order was passed on 19/8/2014. That also I have quoted there in the writ petition. And your lordship will find the order is at page 7.
Yes.
But one portion has been left out that I am reading out. That 19/8/2014, Lord and Council for the State accepts notice on behalf of the opposite parties. Extra copies of the writ petition be served on the Lord and Council for the State as prayed for by the Lord and Council for the State. Put up this case 4 weeks after for obtaining instruction filing counter. Then 19/8/2014 had no coercive action shall be taken against the petitioner pursuant to the order under Annexure 1 passed by the state level scrutiny
So
committee.
let's read the single judge's order here. 4/9/2017. Let's read that first, sir.
That is right. But what I, my lord, beg to apprise your lordships, my lord, this case, the no count file and various documents which are stated in the writ petition to have been furnished, not taken into consideration with its probative values as directed by the division bench. And my lord, the no counter was filed, but the case, your lordship will find in page 9, we have stated that another case referred to our case and that was tagged on 16/8/2017, page 9, in paragraph 17. And then, my lord, citing the judgment of my lord Justice Gopal Gowda in that division bench, that writ petition was remanded. That was disposed of. And this writ petition was posted to another date. And on that date, 4/9/2017, the writ petition was disposed of in a casual manner, without counter, without.
You're not reading that order, sir. We're waiting for you to read.
Yes,
You're
I'm
refusing
reading.
to read.
Yes, my lord, I'm reading. Lordship, kindly see. I'm reading page 18. This writ petition involves a challenge to the order passed by the state level scrutiny committee in FCC number so and so. Fact discloses that in the first round of the litigation, at the instance of the petitioner, this court in disposal of the WPC number so and so directed the state level scrutiny committee to have a de novo trial of the proceeding. It may be stated here that the proceeding initiated involving the petitioner in pursuance of the direction of the Honorable Apex Court in civil appeal number so and so, and consequent upon allegation against the petitioner that though the petitioner is Pano Christian, but in the grave of claim of Pano Hindu, he is taking away the benefits available in the Pano Hindu in the locality. On the remand of the proceedings pursuant to the direction of this court, the matter was taken up, and in this remand proceedings, the state level scrutiny committee observed the statement deposed by the witnesses before the investigating officer disclosing that the petitioner belonged to Pano Christian have not got the support of very same witnesses also before the state level committee in the cross-examination submitted by the petitioner is Pano Hindu. This is not correct finding. I'll show to you, Lordship. State level scrutiny committee declared all these witnesses hostile. Though the petitioner was provided opportunity to bring further evidence, yet the petitioner failed in bringing any documents or evidence establishing his claim that he belongs to Pano Hindu. Circumstantial evidence rather discloses that the petitioner, since Pano Christian, not only following the Christian religion, but has given his children Christian names for the clear materials against the petitioner, establishing that the petitioner does not belong to Pano Hindu, rather he is Pano Christian. The state level scrutiny committee had no than allowing the application directing cancellation of the certificate granted in favor of the petitioner, and at the same time also recommending for initiation of proceeding against the petitioner for his illegal taking the benefit available to scheduled caste in the locality for the established materials and the clear observation of the state level scrutiny committee, and in absence of any further materials and witnesses in establishing the case of the petitioner, in spite of chance given to him by this court finds there is no infirmity in order and so on. But your lordship will find this is a casual order has been passed without going into the veracity of the materials discussed, scrutiny committee, and illegally rejected. That lordship kindly see page 20. And all documents which are furnished also I have given in the writ petition below. Lordship kindly see below. My lord, page 20. My lord, I am reading 1, 2, 3, 4, 5th paragraphs. No, my lord, your lordship kindly come to page 21. Page 21. Yes. Whereas in pursuance of direction given by the Honorable Supreme Court in their judgment dated so in the matter Kumari Madhuri Patil and others versus Additional Commissioner Tribal Development and others, copy of the inquiry report along with the so-cause and recorded statement of the alleged persons were sent to Tahsildar Raikia by letter number so for publicity of the concerned locality by issuing a public notice by beat of drum inviting objection from any person's association within 15 days. Whereas the Tahsildar Raikia has published the notice in the locality on 27/10/2013 inviting objection as reported by letter number so. But here lordship kindly mark here. This is important. No objection has been received by the chairman of the SLC within the stipulated period. Hence, the committee decided to and pass an order. Whereas the SLCC duly considered the IO's report, so-cause reply, the recorded statement of the alleged persons and other relevant records, and unanimously held that the allegation of the fake caste certificate in this case is true due to the following reasons. In the so-cause reply dated 1919, the alleged has submitted that the witnesses have deposed before the IO against him as belonging to Pan Christian since he had filed case against them for destroying his house in the last riot. Now, on the contrary, the said witnesses, namely Gunjar Pradhan, my lord Bisikesan Pradhan, Naresh Digal and Raja Digal appeared and deposed before the SLCC on 21/3/12 that they alleged that his father belongs to Pano Hindu community. But the said statements are not accepted by the SLCC as they became hostile witnesses and retracted. Moreover, the committee came to conclusion that the alleged might have gained over the witness, and the witness at the latter stage changed the version by supporting the alleged person. But here I pause for a moment. The statement recorded earlier, that should be given a go by because there has been a de novo inquiry. So he has to proceed after the judgment of this honorable court. Whatever the statement is given, that supports that it is his Pano Hindu. But then lordship kindly come to, it is found from the report of the IO as well as the deposition of the alleged before SLCC on 21/3/2012 that both the alleged and his father have married in Pana Christian community, and now his mother and wife after the marriage follow Hindu rituals. But the said contention of the alleged is not accepted by the committee since in prevailing Hindu religion and custom, one should marry within his own community and religion. Hence the marital links of the alleged and his father established the fact that they belong to Pana Christian community. Moreover, the alleged failed to produce any evidence practicing Hinduism in the matter of birth, death, rites, and visiting to temple to ascertain his religious practice as Hindu, etc. As a matter of principle,
we'll continue after that.
3. I think I have covered that para
Yes,
2.
yes.
As a matter of principle, Hindu parents generally inclined to name their child as per Hindu custom and convention. If at all the parents of the alleged belong to Hindu, then it can never be believed beyond reasonable doubt that people living in remote area of the Kandhamal district will give the name of their child as Michael, which denotes the name of the Christian people. Then it is found from the statement of the alleged before the SLC on 729 that the name Michael is not a Hindu name, it is a Christian name. It is found from copy of the UP school admission register of Sugodobadi school attached to the iOS report that the alleged took admission in class 2 on 14/9/74 by the SL serial number 921 and caste and religion has been mentioned as Pano Hindu. It is also found from the copy of the RORs by Khata number so and so, which stands recorded in the name of the grandfather of the alleged and alleged respectively by mentioning the caste as Pano. But the set entries of the caste Pano cannot be accepted by the committee as the alleged and his parents might have changed the caste as Pano with the alternate motive in order to grab the benefits meant for the scheduled caste people. For the inquiry report, it reveals that out of 11 of the village of Kaliguda, except 3 families, all other 8 families belong to Pano Christian community, including the family of the alleged. The family members of the alleged are attending Roman Catholic Church at Sabdaga. So on the basis then the following directions have been given. And Lordship will find that all these documents, my Lord, in the Madhuri Patil case, that very emphasis has been also given that on the school register. That is paragraph 19, that is the document. It was Dita.
No, but your point is that they actually did not support the case of the state. All of them turned hostile. Earlier, they had all said he was actually Christian, but when they came before the SSLC, they did not stand by their statements.
Yes.
But they all turned hostile.
My Lord, that was, my Lord, that your Lordship will find from the judgment that observation given in paragraph 6
Anyway,
of the
that is okay. I'm just trying to understand.
Obviously, before the IO, an officer who is, my Lord, that is every likelihood that compelling that giving us evidence. That is why, my Lord, that should be given a go by because it has been a direction for de novo inquiry. So whatever statement are recorded, they should proceed upon that and onwards. And, my Lord, coupled with that, your Lordship will find all the documents which
what is the proof of conversion which the state is relying on apart from the name? Apart from name change, is there any particular document which shows they have converted to Christianity?
No, nothing. No document is forthcoming.
Anyway, let me ask. The state. Yes.
My Lord, there is a consistent finding of both the SLC as well as his Honorable Single Judge that they belong to Pano Christian. Now, the findings, if your Lordship is at para 21, there was a riot earlier, and in that riot, a criminal case was registered, and they claimed that we are all Christian people, so we are victimized. And that has been taken note of in para 1 of the page 21. I'm just reading in the so-called reply so-and-so, the alleged has submitted that the witnesses have deposed before the IO against him as belonging to Pano Christian since he had filed case against them for destroying his house in the last riot. Now, on the contrary, the said witnesses, namely so-and-so, appeared and disposed before the SLSC on that the alleged and his father belong to Pano Hindu. Same person, the same witnesses once in another.
They all statements only made to a police officer. So how can you go by that? You see, the point is they have turned hostile. So the basis on which you started this entire inquiry into finding out whether he's Christian or Hindu, basis has gone.
Yeah, that is the credibility of the witnesses which he has examined.
Correct.
That is now it is found from the report of the IO as well as deposition of the alleged before this one, so that both the alleged and his father have married in Pano Christian. There, your lordship knows what are the parameters to be followed for the purpose of determining the community. Now they are all married. They are going to church.
No. So if it is a marriage in a church, there must be some entry in some register maintained by the church that the marriage is in place in the church. That is one way. The other is to, if there's a formal conversion.
These are not denied, my thing.
No, what not denied? He's very much denying. He says he's a Hindu. He's maintaining that he's a Hindu.
Yes.
He's not accepting he says merely because my name is Michael.
Your lordship is asking what are the documentary evidence available?
If at all. See, if there is no oral evidence, there must be documentary. There's neither. Oral evidence would have been in the form of these witnesses who would have said, no, he's a Christian.
Onus of proof lies on, as per that decision of the honorable, onus of proof lies on the person who is saying that I am the scheduled caste.
No. You have
he is trying to take the benefit.
No. It will shift to him after you prima facie establish. See, you have started this inquiry. The inquiry started because of the Supreme Court judgment.
Yes, my lord.
So you have started the inquiry. The state has started the inquiry into whether, in fact, he's a genuine scheduled caste or not.
That is a fixed
Madhuri Patil's case has triggered off all this inquiry.
Yes, my lord.
Because they found a large number of fake certificates being issued.
No. Since he is the beneficiary of the alleged caste certificate.
Correct. You are out to show that he is not. The state is trying to show that he is not. So the Tahsildar published a notice inviting objections.
No objection was submitted.
The IO report is there. IO report is
rebuttable by the other evidence. More emphasis is given on the school living certificate, school register. Paragraph 9, may I draw lordship's attention to that.
De novo inquiry was made by SLSC, including the documents relied upon by the vigilance cell and the statement of the witnesses examined the IO. The alleged has issued notice and so the witnesses examined by the IO during inquiry were also issued notice to appear before the SLSC. The alleged and witnesses, namely so and so, the statement of witnesses were recorded in presence of the alleged. The statement of the alleged was also again recorded on the date and kept there. Whereas as per the direction of the Honorable High Court in so and so, the number of proceeding copies of this document were supplied and confronted to the alleged person, and the witness on whom the IO's report has relied were examined in presence of the alleged. He was also given due opportunity of being heard. Whereas the issuance of the direction given by the Honorable Supreme Court, yes. So there was an inquiry. IO submitted the report.
Vigilance cell, they recorded the statements.
Yes, ma'am.
Before the IO, those witnesses made a statement that he actually is a Christian.
Yes, ma'am.
But when they came before the SLSC, they turned hostile. None of them were prepared to say that he's a Christian. And then the inference drawn is they've been won over. But there must be something.
Because the first statement is to be taken into consideration.
No. That is behind his back. He has not had a chance to confront.
And statement before the police.
That's right. Where he cannot cross-examine. Only if they are brought before the SLSC, only so that he can cross-examine them. See, in the school admission also, it's mentioned as Pana Hindu.
Let's clearly see paragraph 9 of the Madhuri Patil judgment. I passed on that judgment.
Para?
9. My lord, that is page 101.
Entries of school register furnish great probability value. There must be some material, Mr. Mohan. We can't go on surmises because it simply says the committee unanimously decided that he was a Christian. How can it be that way?
There is no basis.
There has to be some
Unless any documentary evidence.
Something, yeah. Even oral evidence, somebody should stand up to be supporting the case of the state. No, he's a Christian, then he can cross-examine that man. And look at the consequences. The criminal case should be instituted against him, everything.
Another ground, they have name.
Name by itself is really problematic.
Hindu names also just
there are so many, you know.
But one of
in Odisha, Mona Lisa Mohanty. I came across that name.
One of our friend lawyer was died recently. Jisu Christ Kanun go.
In fact, in the north, Pinky is a very common name.
Yes.
So,
more or less, the committee has relied upon the IO's report. Committee has relied upon the report of the IO.
So that IO's report is based on the statement of these 5 people.
Yes.
So that's the whole problem. The report goes then.
So Lordship can direct them to reconsider.
No. How many times? This has to end now. There's already two rounds are over. You say the present appeal is directed against the judgment dated 4th September 2017 of the single judge, dismissing writ petition civil 15421 of 2014 filed by the petitioner, questioning the order dated 28th June 2014 passed by the state level scrutiny committee (SLSC) in FCC number 32 of 2016, holding that the appellant was belonged to single quotes Pana Christian unquote community, and therefore that the caste circuit issued in his favor declaring as belonging to a scheduled caste (SC) was illegal and obtained fraudulently. Paragraph. This is the second round of litigation on the issue of the caste certificate issued in favor of the present appellant. Earlier, the appellant had filed writ petition civil 17655 of 2009, which was disposed of with this court on 2nd August 2011, remanding the case to the SLSC, asking it to start proceedings de novo, giving opportunity to the petitioner, open quotation, appellant, petitioner, you say, appellant, open quotation, only after supplying copies of those disputed documents to be confronted with, on the basis of which the report has been submitted by the vigilance officer, and the same be placed on record, of course, provide the petitioner to produce his rebuttal evidence, unquote. Paragraph. While issuing notice in the present appeal on 10th October 2017, this court stayed, passed an interim order that no course would be taken against the appellant pursuant to the report of the SLSC and the impugned order of the learned single judge. Stop that interim order has continued since. The background facts are that The appellant has been working as Sikhya Sahayak and is a resident of village Lenguma police station (PS Raikya) in district Kandhamal. Full stop. Pursuant to the decision of the Supreme Court of India in Madhuri Patil versus Kumari Madhuri Patil versus Additional Commissioner Tribal Development, AIR 1995 SC 1994. An inquiry was commenced against the appellate. Full stop. The investigating bracket IO submitted a report through the District Vigilance Cell Kandhamal along with a letter dated 24th November 2008. Full stop. Copy of the said report was sent to the appellant, asking him to show cause why his caste certificate should not be cancelled. Stop. The appellant submitted his reply on 20th January 2009 and on February 2009 appeared before the SLSC. Stop. On that basis, the SLSC passed an order declaring that the appellant did not belong to the Pana Hindu community. Paragraph. This triggered the first round of litigation, which has been referred to herein before, with the High Court, with this court remanding the matter to the SLSC. Full stop. Thereafter, copies of the documents gathered by the SLSC were supplied to the appellant by the SLSC. It must be noted that the Tahsildar Raikya had published a notice in the locality on 27th October 2013 inviting objections full stop. Since no objection was received within the stipulated period, the SLSC proceeded further in the matter. Full stop. It appears that 5 persons had 4 persons had appeared before the IO. No, had deposed before the IO that the appellant belonged to the Pana Christian community. So, in response to the show cause notice, the appellant submitted that the said witnesses had deposed as above against him only because he had filed a case against them for destroying his house in a riot that took place in Kandhamal district. Full stop. When the 4 witnesses appeared before the SLSC on 21st March 2012, they asserted that both the appellant and his father belonged to the Pana Hindu community. Also, in other words, these witnesses turned hostile and did not support the case of the state that the appellant belonged to the Pana Christian community. Full stop. However, it appears from the impugned order dated 28 June 2014 of the SLSC that its members did not accept the statements made by the 4 witnesses to the SLSC that the appellant and his father belonged to the Pana Hindu community. Full stop. The SLSC concluded that the appellant had managed to win over the said 4 witnesses. And they accordingly changed their versions to support them. Full stop. Paragraph. The SLSC then fell back on the report of the IO to the effect that the appellant and his father had married into the Pana Christian community. Full stop. However, in the same breath, the IO noted in his report that the appellant's mother and wife still followed Hindu rituals. Full stop. The SLSC then proceeded on the surmise that since the appellant was named single quotes Michael, unquote, he must be a Christian. Full stop. In doing so, the SLSC overlooked the entry in the school register, which clearly showed that the appellant was a Pana Hindu. Full stop. The RORs of certain lands stood recorded in the name of the grandfather of the appellant and the appellant, mentioning their case as single quotes Pana, unquote. Nevertheless, the SLSC chose to reject all of this evidence. Again, on the surmise that the parents of the appellant, open quotation, might have changed the caste as Pana with an ulterior motive in order to grab the benefits meant for SCP, unquote. It is thus seen that the SLSC both chose to both reject the oral evidence of the 4 persons who, by turning hostile, actually support the case of the appellant, as well as the documentary evidence of the school register which showed the appellant to be a single quotes Pana Hindu, unquote. In this context, it may be noted that in Madhuri Patil versus Additional Commissioner, Tribal Development, Supreme Court observed is under. Just take A to A. There had to be some credible evidence, either oral or documentary, which showed that the appellant was in fact not a Pana Hindu, but a Pana Christian. However, there is no discussion of any such evidence in the imbued order of the SLSC, which throughout proceeds on conjectures, and surmises. Paragraph. For the aforementioned reasons, the court finds the impugned order dated 28 June 2014 of the SLSC in FCC number 32 of 2012 to be unsustainable in law, and it is hereby set aside. Correspondingly, the impugned order of the single judge is also set aside. Paragraph. Learned AGA then submitted that the matter should once again be remanded to the SLSC for a 3rd round of inquiry. Full stop. Considering the fact that this has gone on for more than a decade now, it will be a harassment of the appellant if a third level of if for a third time an inquiry is started against him regarding the genuineness of his caste certificate. Consequently, the court declines this prayer. Paragraph. The writ appeal is allowed with no other sister cause.
May Lordship kindly see Annexure 3. It is a consequential order. Lordship may also.
Yeah, the consequential order is also set aside.
That Lordship kindly.
Right.
Referring to that, it is passed.
Okay.
Annexure 3.
All right. The consequential order bracket Annexure 3 is also set aside. Okay.
Weekly list item 59.
None of is dismissed.
Weekly list item 60.
None of is dismissed.
Weekly list item 61.
61, no instruction.
No instructions dismissed.
62.
May I please, Lordships? I'm filing the present address of the respondent number 1 and 2.
Too late, madam. That should have been done 5 years ago. Tell us what the matter is.
Should the appellant number 1 has died in the meanwhile?
309 days delay. What is the explanation for the delay?
Should the appellant number 1 was looking after the matter, he was ill. In the meanwhile, he died, Your Lordship.
That's all right.
Your Lordship, there is a delay of 200 days, Your Lordship.
309. Anyway, anything about 90 days, you have to have a very clear explanation.
Your Lordship, grant me one opportunity. Grant me one opportunity. I have annexed the medical reports. You are suffering from, and due to that decision, he passed away in the meanwhile.
All these are not excuses, madam. 309 means almost a year. There's an inordinate delay of 309 days.
Your Lordship, may grant me one opportunity to satisfy Your Lordship.
No. Right, satisfied. This is already a 5-year-old matter.
Lordship, I have annexed the medical reports, Your Lordship. The judgment was passed on 2010-2017. And
no, only appellant 2 died, not appellant number 1.
No, so appellant number 1.
Appellant 1, there is no excuse at all.
Your Lordship, appellant number 1 has died in the meantime, Your Lordship.
That is different. When you filed it, he had not died.
No. In the meanwhile, he was suffering from disease, and
so he, at the time of filing, madam, when you filed it, it was already 309 days old, delayed. You have to explain that delay.
Lordship, the appellant number 1 who was looking after the case, he was not well. And Lordship, grant me one opportunity.
Madam, we're not adjourning. So don't go that route at all. We are simply not adjourning the case. You can argue to your heart's content on why we should condone the delay.
The appellants belong to the ST community, Your Lordship. They are not. They belong to the district of Koraput, Your Lordship.
It's all right. All that is not an excuse. They all know about litigation. This is a writ appeal. If they were filing writ petition, that they don't know the law and all that. This is a writ appeal. By now they know. They're already filed parties. They're already parties to writ petition, so they know the procedures.
Bishop, he was ill. The person who was looking after the case was not well, Your Lordship.
All right. Say IA number.
Lordship, grant me one opportunity. Lordship, call it tomorrow, Your Lordship.
All right. IA number, Miss Case number 619 of 2017. Oh, this is for certified copy. This is 3160. is Williams. Yeah, 317 of 2018. This is an application seeking continuation of delay of 309 days in filing of the appeal. Full stop. The only explanation of the delay is given in para 3 of the application, that appellant number 1 who was looking after the case, was seriously ill and was advised till 2017. And that immediately after his recovery, he has filed the present appeal. Paragraph, it is seen that the impugned order is dated 21st February 2017, and the bed rest continued till 2010-2017. Even thereafter, the appeal is not immediately filed. First of it was ultimately filed only on
the appeal was filed
April
immediately on 27/10, Your Lordship.
2018. Paragraph. In the circumstances, the court is not satisfied. You say 2018 with the application for condonation of delay, which was not even filed along with the appeal. Full stop. There has been a lackadaisical approach at every stage of the proceedings. Full stop. The court is not satisfied that the delay is for bona fide reasons. Consequently, the IA is dismissed. Therefore, the appeal is dismissed.
Lordship, the appellant was directed for bed rest till 20th/10/2017. The appeal was filed on 27/10, just after 7 days, Your Lordship.
Weekly list item 63.
All right.
Please, my lord, I have been busy, my lord. My lord, I have given a date chart, my lord. Lordship, may kindly have a glance, my lord. Has your lordship got that date chart?
Yes.
My lord, the brief fact of the case was that the writ petitioner and another constable was deployed for dispersal of cash by the reserve office. You know. They came back with the remnant amount, couldn't disperse the cash. You know. After it was opened, my lord, and they kept it in the magazine, my lord, in the guard's room, my lord. And the key was with the writ petitioner, my lord. When money was taken out and it was counted, there was a shortage of near about 4 lakhs. My lord, then my lord, both the writ petitioner and Nakulna deposited 2 lakh rupees each, and the money was dispersed to the persons who are entitled to the salary. Then thereafter, the Ramesh Chandra Sahu made an grievance that he has not taken the money, and therefore an inquiry was ordered by the SP. In the inquiry, it was found that the other constable has taken the money out, and he also confessed to that. Then by that time, the money has been disbursed to the persons entitled to this. Then he prayed for recovery of that money. This petitioner told that my share of 2 lakhs rupees may kindly return to me now that he has confessed. But as the same didn't yield any result, he filed a writ application, my lord, wherein the appellant was not named, individually not named, but was named by designation. The appellant, on receiving a message from the police office, sent his parawise comment, which unfortunately was not incorporated into the counter filed by the opposite party number 1 and 3, 1 to 3 Millard State. They kept 1 Millard, and the writ application, the order was passed, page 61. Your lordship may kindly have a glance. Has your lordship got in?
Yes.
Page 61.
Yes.
But, my lord, by filing the writ petition, the petitioner has sought for a direction to the opposite parties to forthwith refund an amount of rupees 2 lakh, along with interest, which amount was deposited with N.K. Patel, Khurda, on 3/6/2005, under duress by the police authority, based on a false allegation against the petitioner to make good the shortfall in the government fund. It is ascertained in the writ petition that the matter was inquired on being directed by the SC. That will be wrong, my lord. There was no direction from the High Court, my lord. It was a direction by the IIC to SI R.K. Panda, and in the said inquiry, N. Naik confessed his guilt, and it was found that the petitioner was not responsible for the incident of shortage of funds. the petitioner alleged that in spite of such revelation, the money recovered from the petitioner on duress has not been released, and thereby the petitioner is constrained to file the writ petition seeking the above direction. This matter is in list for last so many days, and the London Additional Standing Council was directed to file counter affidavit. In the meanwhile, state government has filed counter affidavit. In paragraph 3 of the counter affidavit, it has been submitted as follows: that it is humbly submitted that the grievance of the petitioner who is working at present as a police constable under the state government are cognizable by the London State Administrative Tribunal, as the petitioner has rushed to the Honourable Court in lieu of approaching the London State Administrative Tribunal. The repression as laid out is not maintainable, thus the writ appeal liable to be rejected, my lord. My lord, this was the only ground taken by the state opposite parties 1 to 3, in spite of the Paraguay's comment given by the submitted to the police headquarters, my lord, by under Annex 2 by the present appellant, my lord. Then considering the demands of the petitioner, this court finds that the petitioner was not responsible in the matter of loss of rupees 2 lakhs. The court further finds that the collection of the amount from the petitioner was without any basis and without even any fault at the instance of the petitioner. The amount involved was illegally collected by opposite party number 1 and 3 from the petitioner while he was working as a police constable under the state government. The recovery from the petitioner has nothing to do with his service, and such I reject the plea of the State Council that the matter is cognizable by the State Administrative Tribunal. Stand of the state in the regard is illegal in as much as the collection of the amount from the petitioner has nothing to do with the petitioner's service. The recovery was made on account of the loss of fund. After conducting an inquiry, it was found that the petitioner was not involved in any way in the loss of the money, and the recovery from the petitioner was therefore absolutely illegal. Petitioner submits that he had to deposit the amount by taking loan from bank and is paying huge interest on the terms for grant of the land. Under the circumstances, while allowing the writ petition, this court directs the RI Khorda opposite party number 4, that is the appellant, to refund the amount collected from the petitioner under duress, considering the submission of the petitioner that for making this deposit, the petitioner has taken a bank loan with heavy interest as available at Annex 2. This court directs the RI Khorda opposite party number 4 also to pay interest. It is charged by the bank to match the entire loan refund. Refund as directed herein be worked out within a period of 2 weeks from the date of communication of the order, my lord. Then, my lord, may I draw your kind attention to Annex 2, my lord, page Lord, 23, my lord. Has your lordship got it, my lord?
Yes.
This is the Paraguay's comment submitted to the Deputy Commissioner of Police Office, Bhubaneswar. That is the police headquarters, my lord, the Commissioner's office. My lord, your lordship may place this. This was categorically stated that in paragraph 6, my lord, page 24. Constable Ramesh Chandra Sahu, that is the writ petition, and Constable Narayan Naik escorted the cash from District Police of Khorda, Bhubaneswar to different police stations and posts of Khorda district. As C1677, that is the writ petition, is one of the part of the escort party, he is equally responsible for the shortage of cash with that of the constable. However, on my request, SP Khorda directed IIC Sahid Nagar PS to inquire into the matter. On the request of IIC Sahid Nagar PS, Narayan Naik was granted 5 days here to enable him to keep a sharp watch on the movement of the said constable for the purpose of successive inquiry.
Mr. Mohanty, why are you aggrieved by this order?
My lord, they have recovered it from my salary, my lord. It was paid to the government employees, my lord. I am not a beneficiary of that tax rupees.
But that's a separate cause of action. So why are you challenging this order?
But because there was an order to recover it from my income, my lord.
No.
So where is that order?
That
No,
is, I was reading,
Lord,
my lord. My lord, your lordship, my lord, I have nothing. The Ramesh Chandra Sahu is entitled to a refund. Let him be refunded. But why should I pay? My lord, your lordship will kindly.
No. Did you deposit it in the government treasury?
No, it was deducted from my salary, my lord.
No. When he deposited 4 lakhs.
Yes, my lord, it was deposited to the government fund, and the salary which was not disbursed, the part of the salary, it was written and kept in the magazine while it was stolen. And after the deposit, this money was disbursed to the persons whose salary was kept there, my lord. And that the other constable gave an undertaking that I will return it to
But where is 1 minute. Let's go step by step. If you come back to the impugned order.
Page 62, your lordship may kindly see.
Yes.
But last
under the circumstances while allowing the writ petition.
Court directs the RI Khurda opposite party number 4 to the amount collected from the petitioner.
No. You did not inform the single judge that this was not deposited with you, but
my lord, I was not named as an individual, my lord. I was named as by my designation, and respondent number 1 to 4 were all police functionaries, my lord.
Where have you mentioned what happened after this order was passed by the single judge? Where have you said that?
Yes, my lord, your lordship may kindly see that is also the inquiry report, my lord.
No, sir. After the single judge this order, what happened? Where have you narrated the facts after the passing of the order by the single judge? Where have you narrated that?
My lord, I have that it was deducted from my
salary.
Yes.
My lords may see page 7 of the bill.
7 of the appeal?
Yes, my lords. Para 13 and 14. That is the only thing that has been stated.
No, where's the question of recall? So I think the stand now taken is so different. Mr. Panda, you're appearing for the same party.
Yes, my lord.
No, he is appearing for the.
I am appearing for the other side.
Writ petitioner, my lord.
No. Where have you said, Mr. Monty, that they are recovering it from a salary?
My lord, IA number 534, your lordship may kindly see.
In the writ petition?
Yes, my lord.
No, in the writ appeal.
Writ appeal, my lord.
Your lordship may look at para 7 of the IA.
That during the pendency of the appeal, the opposite party Tesano 4 issued a letter by district office letter that under annexed directed to recover the amount of rupees tax along with interest from the appellant petitioner from his salary in 10 consecutive monthly installments of rupees 24,549 to be paid in the respondent. Accordingly, total sum of rupees 2 lakhs only has been deducted from the appellant, which can be revealed from the pay slips of the DO and to issue copy of the same are annexed here.
What's the delay?
But the delay has been condoned by taking the peculiar facts and circumstances.
Right. So who's for the state now?
Whether they have
justify this, sir. This is deposited in the treasury. You can't deduct from his salary. How can you deduct from his salary? It did not. He did not get the money at all.
Yes, my lord.
It's very unfair, sir.
What has happened, my lord, because of the order passed by honorable single judge?
Maybe.
Yes,
the single judge said because RI collected it, RI should refund. RI meaning the state.
Yes.
Not RI doesn't mean individually the RI.
Exactly, my lord.
So you refund this, please pay back this money. It's not fair at all.
Yes, yes. That was something, my lords, which the higher
Your
officials
Lordship,
of
our
opinion
counter is also
committed a mistake, my lords.
Yeah,
They should have given me the compensation from out of the government funds.
Exactly.
I had already deposited.
Correct.
I did not implead the writ appellant in person.
Right.
I impleaded him in lieu of
Official capacity. Correct.
Yes.
Correct.
And the direction was also in the official capacity to be refunded.
Correct. You see, this appeal is directed against two orders passed by the single judge. One is the judgment dated
in
27 January 2015 of the learned single judge allowing writ petition civil 9195 2008 filed by respondent number 1 Ramesh Chandra Sahu, whereby the single judge directed
Page 62, my lord.
Yeah, the revenue inspector bracket RI Khurda.
So it's not the revenue inspector, it will be the reserve inspector of police.
What's that?
Reserve inspector.
Reserve, okay, the reserve inspector bracket RI of police Khurda to refund to respondent number 1 herein the sum of rupees 2 lakhs together with interest stop this. Further challenges to an order dated 9/10/2017 passed by the learned single judge, dismissing miss case number 17216 of 2017 filed by the present appellant. In recall of the aforementioned order. Full stop. The said application was dismissed on the ground of delay, as it was filed more than 2 years after the passing of the original order. Paragraph. It must be noticed here that the delay from the present appeal
that has been condoned.
Yeah, has been condoned by an order dated 13th May 2019 of this court. Stop. The second factor to be noted is that during the pendency of the present appeal, the appellant filed IA number 534 of 2019, in which, inter alia, he stated that pursuant to the aforementioned judgment dated 27th January 2015, respond before that is the Deputy Commissioner of Police Bhubaneswar had issued orders for deduction from the salary of the appellant. The entire sum recoverable in 10 consecutive monthly installments of rupees 24,759. Stop. It was stated that by the time the application was filed, that is 4th August 2019, a sum of rupees 247585 had already been deducted from the appellant, and the pay slips evidencing such deduction were annexed as Annexure 8 series. Paragraph. The background facts are that respondent 1, Ramesh Chandra Sahu, and who had filed writ petition civil 9195/2008, and 1, Narayan Nayak, were constables of the Reserve Office, Khurda. They were commanded from the RO, Khurda, to District Police Officer, Khurda, for cash escort duty. On 20th May 2005, both constables escorted cash of rupees 24,97,853 from the DPO to the RO, Khurda. Paragraph. Again, on 26th May 2005, they escorted cash of rupees 30,967. They disbursed some cash at the RO and other police posts. Due to non-availability of vehicles, they could not disburse the remaining cash of 827,888. They kept this in an iron chest of the magazine guard under lock and key and kept the key with them. They performed magazine guard duty on 30th May 2005. They were relieved of this duty at 4 p.m. on 31st May 2005. We say while the respondent 1 was relieved from the magazine guard duty on 31st May 2005 at 4 p.m. Narayan such. Paragraph. On 1st June 2005, respondent 1 was again detailed for cash escort duty, along with Havildar Ashok Sethi and Constable Amiya Kumar Biswal. At around 11 p.m. on 1st June 2005, they returned to the RO with cash. Since it was late night, they kept the cash and vouchers in the iron chest in the presence of a magazine guard, sentry DP Kullu. The key of the iron chest was kept with respondent 1. Even on 1st June 2005. Paragraph. On 2nd June 2005 at 7:30 p.m., the iron chest was opened by respondent 1 in the presence of Havildar Ashok Sethi, Constables A.K. Biswal and Narayan Nayak, and DP Kullu. When the cash was counted for disbursement, a shortage of rupees 4 lakhs was detected. This was reported to the RI Khurda. On scrutinizing the vouchers, confirmed the shortage. Paragraph. On 3rd June 2005, purportedly under the duress of the RI, both respondent 1 and Narayan Nayak deposited rupees 401,112
in equal installments
to avoid departmental proceedings. Said amount was then paid or disbursed to the staff to whom the payment is due. This was subsequently reported to the Superintendent of Police, Khurda, who in turn directed the IIC Shahid Nagar to look into the matter.
On my grievance, respondents.
Right. Paragraph. On 3rd December 2005, the Sub-Inspector of Police, (SI) of Shahid Nagar PS undertook an inquiry during which Constable Narayan Nayak confessed to his guilt. Present the SI as well as respondent 1. Apparently, FIR being PS Shahid Nagar PS case number 169 of 2006 under sections 451/380 of IPC was registered, and the said FIR in the FIR the trial is in progress. Paragraph. Respondent 1 filed writ petition civil 9195/2008 in this court for a direction to the state authorities to refund the sum of 2 lakhs along with interest which had been deposited in the RI Khurda. The present appellant was impleaded as opposite party number 4.
No, Millards.
But not by name. The present appellant was not impleaded by name. But in the writ petition, the RI Khurda was impleaded as opposite party number 4. Paragraph. A common counter affidavit appears to have been filed by the Additional Standing Counsel, ignoring the paravis comments provided by the present appellant. Full stop. On 27 January 2015, the learned single judge allowed the writ petition, civil 9195/2008, and in the operative portion of the said order, the following directions were issued. Take from page 62, last paragraph of 62, the whole of paragraph.
Only one thing I'd like to say, my lords, here.
Yes.
So far, no refund has been made to me.
I see. Although they've deducted from his salary.
Yes, my lord. No refund.
Then we'll ask them to straight away pay that entire amount to you, no?
I have filed a contempt there.
Okay.
It is actually, my lords, the DCP misinterpreted the single judge's order.
Yes. An intimation was received by the appellant from the Commissioner of Police, Cuttack.
Bhubaneswar.
Acha, Commissioner of Police,
Bhubaneswar.
Bhubaneswar, to implement the order. Full stop. The appellant then requested the commissioner to seek review of the order passed by the learned single judge. Full stop. Ultimately, on 13th September 2017, Miss Case number 17216 of 2017 was filed by the appellant, seeking recall of the order dated 27 January 2015, which came to be disposed by the second impugned order dated 9th October 2017 on the ground of delay.
Two grounds, my lords. Ground of delay and that a miscase was not entertainable in a disposed.
Further, it was held that in a disposed of case, a miscellaneous application was not maintainable. Paragraph. This court has heard the submissions of Mr. Ashok Montil and Senior Counsel appearing for the appellant, Mr. Devashish Panda, learned counsel appearing for respondent 1, and Mr. Kuntia, learned additional government advocate appearing for the remaining respondents. Paragraph. At the outset, Mr. Mohanty, appearing for the appellant, states that the appellant has no grievance about refund being ordered by the learned single judge in favor of respondent 1. His only grievance is that the amount having been deposited in the treasury of the government, ought not to have been directed to be recovered from the salary of the present appellant. Full stop. He submitted that the state authorities had wrongly understood the direction of the learned single judge to mean that the present appellant was personally responsible to make the refund of the amount deposited by respondent 1. Full stop. He stressed that the amount was in fact deposited with the government treasury.
Well, it was dispersed. Well, salary.
Yes, amount was in fact disbursed as salaries of the staff, as disbursed to the staff as salaries, and not retained by the appellant at any point in time. Full stop. Paragraph. Mr. Devashish Panda, learned counsel appearing for respondent 1, states that his only concern is that respondent 1 should get the benefit of implementation of the order of the learned single judge. Full stop. He pointed out how till date he is yet to receive the complete refund amount together with interest as ordered by the learned single judge. Full stop. He points out that in fact he has filed contempt case in this regard before the learned single judge, in which notice has been issued. Paragraph Mr. Kuntia Learned AGA submitted that the action was taken because the impugned order stated that it is the RI who should make the refund. And it was therefore understood as if it is the RI who was personally responsible for the refund of the amount. Paragraph. Certain facts are undisputed. Full stop. One is that the respondent number one, that the appellant herein, along with Narayan Naik, was constrained to make the deposit of rupees 4,01,112.
The respondent will not appellant.
Yeah, sorry. The appellant along with, that the respondent number one along with Narayan Naik had to deposit rupees 4,01,112 only to avoid departmental proceedings. Full stop. Subsequently, it was found that it was Narayan Naik who had confessed to the guilt. In other words, respondent number one was not in any way responsible for the shortage which was detected in the cash which was under their custody. Full stop. Even the state has not proceeded against respondent number one departmentally by accepting the above version, and on the basis of which FIR has been registered at the Shahid Nagar PS. Paragraph. The second factor to be noted is that the amount deposited by respondent number one and Narayan Naik was immediately disbursed to the staff as salaries. Full stop. It was not retained at any point in time by either of them, and definitely not by the RI. Full stop. The third factor to be noted is that the RI was implemented by designation as opposite party number 4 in the writ petition civil 9195 of 2008 and not by name. Full stop. Therefore, when a direction was issued by the learned single judge that the RI should refund the above amount to respondent number one, it could not have been understood as the RI having to personally, from his personal funds, having to refund amount. Full stop. The direction was obviously that the state should refund the amount. Full stop. In the circumstances, the action of respondents, respondent 3 and respondent 4, in directing the deduction of the entire amount in 10 installments from the salary of the present appellant was wholly uncalled for and not legally justified. Paragraph. With the appellant not having benefited in any manner whatsoever as a result of the shortage found in the cash, and with the amount deposited by respondent number 1 and Narayan Naik already having been disbursed to staff as salaries, there is no justification whatsoever in proceeding to deduct the said amount from the salary of the present appellant. Paragraph. For the aforementioned reasons, the following directions are issued. 1. The entire amount deducted from the salary of the petitioner, that is rupees
2,40,000, 47,000 somewhat.
Rupees 2,47,585.
Yes, sir.
Be immediately refunded to the appellant within a period of 4 weeks from today, failing which the said amount will be refunded together with simple interest is 6% from which was the last of the, from the date of the filing of IA 534 of 2019, that is 4th August 2019, till the date of payment. 2. The pursuant to the directions issued by the learned single judge in writ petition 9195/2008, the amount due to respondent 1 be refunded to him by the state within a period of 4 weeks. Failing which, again, simple interest on the said sum will become payable to respondent 1 at 6% per annum from the date of the judgment of the learned single judge, that is 13/8/2015 till the date of payment. The writ appeal is disposed of in the above terms. A copy of this order be produced before the learned single judge before whom the contempt petition is pending for further directions.
UNPC number 1868 of 2016.
1868 of
2016.
Yeah. 1868 of 2016 must be.
Yes, me.
Yeah, 16. All right.
Obliged, my lord.
All right.
If the date of the single judge's order is 27/1/2015, which has been challenged.
All right.
It is not August 2015. It's 27th January 2015.
Right.
Last part of the office order.
Item 64.
Well, I prefer not press, my lord.
Not press disposed of.
Item number 65.
Lordship, no instruction. Lordship.
No instructions. All right.
Item 66.
For respondent 3, my lord.
May it please.
I am for respondent 3.
May it please, your lordship. Lordship, I am submitting a note of submission.
Yes.
Kindly be accepted.
Anganwadi worker.
May I place it, your lordship?
Right.
Lordship, this is an appeal that has been preferred against the judgment of the single judge, wherein the challenge was made in respect of the order of the ADM, in which the engagement of the present appellant as the Anganwadi worker was cancelled. Single judge has upheld that. Therefore, I am before your lord. The facts are such that pursuant to the advertisement.
So the residential certificate was not issued within 6 months.
Yes, your lordship.
That's a mandatory condition.
Yes, your lordship. May I place the matter, your lordship? Certificate, it was not the up-to-date residential certificate that was not produced, and that was produced the very next day before the scrutiny, because of which they had accepted it. And the caste certificate also, your lordship, the same.
Not produced at the time of...
The caste certificate also was not valid for that 6 months validity period, and it was produced at a belated stage. Therefore, your lordship, I would like to submit that.
Yes.
That the cutoff date that is meant is for essential qualifications.
Yes.
Like educational qualification or professional experience, age limit.
Where do you get that? Where do you get that? It's only for essential qualification and not for these things.
Lordship, for that I rely on a judgment. I have flagged it as 1.
No, but a caste certificate, if you're coming under the SC category.
Yes, your lordship.
And for Anganwadi Center, residential certificate is an essential document.
I have produced the caste certificate, but it was not the up-to-date.
Residential certificate, up-to-date residential certificate is an essential document.
I have produced them, your lordship.
No. Producing them before the cutoff date is essential.
Yes, your lordship. Then my lordship may kindly come to flag. The Supreme Court judgment that I have annexed.
Yes.
A moment, Your Lordship. May I be permitted to place it?
Yes,
Your
please.
Lordship? Lordship, my page does not match because I have downloaded it from a certain different website. Para 16.
No, but what of residential certificate? You're only talking of caste certificate here. This judgment doesn't talk of the residential certificate.
In
fact, it's not in the context of Anganwadi center at all.
No,
See, for Anganwadi centers, there is already a guideline. And there's a series of judgments, including this very bench, that becomes an essential certificate.
It becomes an essential, Your Lordship, but we have produced it, though at a belated stage, but we have produced the same.
We have said it's essential and it has to be produced at the time before the cutoff date, or before the cutoff.
Because these, Lordship, these two certificates, especially caste and residential certificate, Your Lordship, she is by birth, she is a SC, which is not disputed, and that cannot change. And as per the residential certificate, Your Lordship, is considered when it comes to reserved categories of persons, especially the scheduled caste who come under the first phase of the reserved categories, Your Lordship, they should be considered.
Actually, the case law of this court is very different. The case law says there cannot be any dilution of that.
That she has given a credential also. That because she has applied for it and it was not issued to her on time.
Again, we have made that distinction. You may apply, but you may not get it in your hand.
And that was not made available to her. That's why she has produced it at a belated stage. She has applied it much prior to the date.
When did she apply for it?
She applied it on the month of August or August, Your Lordship. And it was issued to her in December.
Where do you get that?
I have mentioned that in the writ petition.
And let's see the
Annexure 3 of the writ petition.
Annexure 3 is only acknowledgement.
Acknowledgement of the means the application.
No. Where do you get the fact that you applied for this updated residential certificate before the cutoff date?
Yes, Your Lordship. I had mentioned it, Your Lordship.
Anyway, that's dealt with in page 7 of the impugned order. Just read that. The ground raised by the petitioner.
Pardon, Your Lordship.
Page 7 of the impugned order of the single judge.
Yes, Your Lordship. The ground raised by the petitioner that she has applied application for residential certificate on 29/8/2012, but she has been supplied in her favor on 4/12/2012. Hence, on the ground, she should not be deprived from the consideration of candidature. But this ground is not tenable in the eye of law for the reason the Select Committee is only supposed to look into the document which will be placed before it as to whether the application is in terms of recruitment rules or the advertisement. The selection committee is not supposed to know the reason for not getting the residential certificate in time. If the selection committee would consider the reason for not getting the residential certificate in time, it will lead to arbitrary and unfairness of the selection process.
What do you say to this last part? It's not in her control, no, when they gets the residential certificate.
But my lords, as per the law, the documents that are submitted on the date of applying, my lords. That has to be considered by the scrutiny committee, and the scrutiny committee cannot relax the norms. My lords, in Hashisha Begum have also held that writ appeal number 122 of 2015, about 2 months. My lords, if I may read, my lords, in that case, my lords, the facts are slightly different. She could not present the documents because of illness. And if I read the operative part, my lords have said at the outset, it must be noted that the decision in Srimati Kunnimani Malik still holds the field. It affirms that the administrative guidelines issued is binding on the selection committee. Neither the selection committee nor the CDPO has been vested with any discretionary power to relax the norms. There are definite time limits for inviting application and verification of documents. So therefore, my lords, her application has to be scrutinized on the basis of the documents. So in that case, what happens is a person will apply some documents, and by the time it gets scrutinized, they will come up with new documents. So that will be the issue.
So the selected one is this Nirupama Kara.
My lord.
You appear for her.
My lord.
She's been working since then.
My lord, I'm working.
Lordship, I would like to place another judgment. Another judgment, Your Lordship.
All right.
At flag 2.
Right.
Page 6 of that judgment.
Yes.
Para 17, Your Lordship. It's of the High Court.
Yes.
Fourth line, Your Lordship. If a person is SC, he is so by birth and not by accusation of the category because of any other event happening in later stage. A certificate issued by competent authority to this effect is only an affirmation of fact which is already in existence here.
So all of this is in the context of caste certificate.
Caste certificate, Your Lordship, but my last judgment, which I have referred to, that it mentions that any documents that doesn't come under the category of essential documents, like
no, but how do you say this is not for an Anganwadi center appointment? This residential certificate is an essential document.
Residential certificate is essential, Your Lordship. Yes. I have produced one which was not up to date, but which I have produced it before the scrutiny because it was not made available to me, not because of any lacuna on my behalf.
Yes. All right.
I have applied it 4 months prior to the year.
I know. This writ appeal is directed against the judgment dated 13th October 2017, passed by the London Single Judge. Rejecting writ petition civil 894 of 2015 filed by the present petitioner, questioning her non-selection as Anganwadi worker bracket AWW at the Lachipur Kha Anganwadi Center bracket AC. Paragraph. Pursuant to an advertisement issued for engagement of AWWs at the AC in question, the present appellant, along with opposite party number 3 and others, had applied. We'll stop. Along with the application dated 3rd December 2000, the appellant, who belongs to the scheduled caste bracket SC, submitted caste certificate, residential certificate, and other documents. Stop. However, both the caste certificate and residential certificate had to be up to date. That is, they had to be valid. They had to be issued within a period of 6 months from the date of the application. Stop. Paragraph. According to the appellant, in respect of both certificates, that is the caste certificate as residential certificate, she had applied for their revalidation more than 6 months prior to the date of the application, the cutoff date, in terms of the advertisement, that is 19th November 2012, but it was issued to her only subsequently. Full stop. The case is that by the time the documents were taken up for scrutiny and verification, that is on 4th December 2012, she produced both the updated documents. Full stop. It is pointed out that despite this and her scoring the highest marks and being the only SC candidate, she ought to have been selected as AWW at the AWC in question. So you were selected and your selection was chosen.
I was selected, Your Lordship. I was selected and I was engaged also.
Right. Paragraph. The engagement and selection and engagement of the appellant was challenged by respondent 3 by filing appeal number AWW appeal number 9 of 2013, which came to be allowed by the Additional District Magistrate Subarnapur by the order dated 9 January 15. Full stop. The ADM observed that which page is the ADM's order? It's here.
The order of ADM is not next.
That by the stipulated date in terms of the advertisement, the appellant produced the 2 updated certificates, and therefore she ought not to have been selected. Paragraph. It is a challenge to the above order in Writ Petition Civil 894 of 2015, which failed, with the learned single judge dismissing the writ petition. Paragraph. Learned counsel, the appellant has relied on the judgments of the Supreme Court in Ram Kumar Gijroya versus Delhi Subordinate Service Selection Board, AIR 2016 SC 1098. And the judgment of the Delhi High Court in Tejpal Singh versus Government of NCT of Delhi, 2005 2052 DRJ 791, to urge that as long as the caste certificate was applied for well within time, the mere fact that it was not produced along with the application, but at the time of scrutiny, would not disqualify the appellant. Paragraph. It is seen that there are 2 essential documents as far as the present case is concerned. One, of course, is the caste certificate. The other is the residential certificate. Stop. In the context of appointment of AWWs at AWs, the residential certificate assumes great significance, since AWCs are located on the basis of since a person to be eligible to apply for the post of AWW at a particular AWC has to necessarily show that the applicant resides in the area in question, which is catered to by the AWC. So in other words, the residential certificate is definitely, as far as appointment of an AWW is concerned, an essential certificate. Stop. Further, neither of the above judgments deal with a situation of appointment of AWW and AWCs. Stop. On the contrary, this court has consistently held that the fulfillment of the requirements for assessment cannot be diluted. Full stop. A set of guidelines have been issued by the state government in the matter of appointment of AWWs. And it has been made clear that there can be no dilution of the requirements therein by the selection committee by relaxing any of the norms. Stop. Can you just give me that?
Please, Manoj. It is writ appeal number 122 of 2015, Hashisha Begum versus ADM Chhatra.
Bracket, you say decision dated
21st of September 2022.
21st September 2022 in writ appeal number.
Writ appeal number 122 of 2015.
Writ appeal number 122 of 2015.
Hashisha Begum versus ADM
Additional District Magistrate, where it was observed as under reproduce the relevant paragraph. It is seen that even before the learned single judge, a similar argument was made, but rejected on the ground that if there is any relaxation in this requirement, it would result in arbitrariness and discrimination. Full stop. Consequently, the court is not persuaded to interfere with the impugned order of the learned single judge. The appeal is accordingly dismissed.
Item 67.
Lordship, kindly see the order dated 13/5/19.
In this case, I was appearing for the respondent number 1, my lord. In the meantime, respondent number 1 expired, my lord, and substitution have not been made.
Is the appellant aware of that?
Yes, my lord.
No, I am not aware.
Yes.
No, I was not aware. He should have rather filed a memo so that it would have been brought to our knowledge to cause the substitution. Because the law also requires that a memo should be filed, intimation should be given. Because after retirement, he was engaged for some time, and thereafter, he has been disengaged, and nobody knows wherever to, because he is a retired employee of the government. And here he was engaged under the OPEPA, that means Odisha Primary Education Program Authority.
Pursue the matter is no more now.
Pardon?
He's expired. Respondent number 1 is expired.
Yes, my lord. He read petition.
That's right. He's now respondent number 1 in the appeal.
Yes, my lord. Regarding area enhanced remuneration and other allowances.
That we are learning that he is not entitled. That division of salary is not, it is excluding the retired employee. That circular which was taken into
account. What is the amount involved?
Amount is
that what no or not, that will be decided, na?
What is the amount involved, sir?
He can say that, my lord.
3,10,000 some more.
Because now his wife, a widow, is survived by a.
Yes.
Who are the surviving LRs?
Widow is there.
No. Give us a full list, sir. Who are the LRs?
Yes. I'll provide this.
All right. Counsel appearing for respondent 1 states that he will provide counsel for the appellant with a list of the legal representatives of respondent 1 who stated to have expired on
on 2/2/2020, my lord.
2020?
Yes, ma'am. During Corona period.
1 to
20 or 21?
20, my lord. Have the
20 is
date
not Corona.
certificate, my lord. 2nd February 2020, my lord.
On 2nd February 2020. Will be. Thereafter, the appellant is permitted to file an application to bring them on record. List on 24 January.
Let the interim order continue.
Yeah, interim order.
Item 68.
Let's fix to 23rd January.
In 68, I'm appearing for the appellants, my lord.
Yes.
Here, I'm on a very limited, my lord, because the matter has been pending for last 20 years. The litigation has been going on for last 20 years. And many of the petitioners in the meantime have crossed the age of retirement also. And my only prayer is, if your lordship will see the annexes 4, 5, and 6, which we are relying upon, shows that Paradip Port Trust still needs a lot of manpower for handling of their loading and unloading, my lord. My only submission would be, if the Paradip Port Trust can be directed to consider these people as and when required, because as per Annex 4, 5, and 6, there is a lot of requirement on daily wage basis also, my lord. I'm
That
not
you
going
make a representation, sir. Let them consider it. You make a representation.
If your lordship will see page 97 of the impugner, last two lines says so, my lord. Page 97.
So then don't press the appeal, sir. You pursue that remedy. Counsel for the appellant seeks not to press the present appeal with liberty to approach the Paradip Port Trust for engagement of the appellants who may be surviving on contractual basis as and when the need arises. The appeal is disposed of, is withdrawn with liberty is paid for.
Oh, bless my lord.
Item number 69.
None appears dismissed.
70 already taken. Item 71.
May I approach? Item 71. The order dated 11/7/2017, the subject matter of challenge in the writ appeal. The Honorable Single Judge has rejected my application regarding the intervention in the writ application, my lord. The brief fact of the case is that the present respondent number 1, my lord, constructed a building violating the norms and without taking the permission from the Special Planning Authority, Jajpur, my lord. Therefore, the petitioner has this is adjacent to the petitioner's house. The construction was made violating the every regulations and without taking any permission, my lord. Though the permission was taken for 2-story building, he has constructed 3-story building. Your lordship can go through the Annexure 1, page 12. The present petitioner, being the most affected person, he has filed a petition for the Special Planning Authority to take action against the person. Accordingly, proceeding was initiated, and thereafter inquiry has been, demarcation has been conducted, and they found that there is a deliberate violation. Therefore, demolition order was passed, my lord. Lordship, kindly see Annexure 4, page 16. As per the directions of though the representation was filed, no action has been taken. The petitioner approached this honorable court. This honorable court directed to take the representation, consider the representation of petitioner. Annexure 4, directions of the Honorable High Court of Orissa and the demarcation report of the Tahsildar Jajpur, the Special Planning Authority Jajpur has communicated this office in its letter dated so to take necessary action as per the provisions laid down in the Odisha Municipal Act and rules towards unauthorized construction of your residential house, deviating the approved plan. It is apparent from the reopen that you have constructed your house completely deviating the plan and added another floor also. As per the report, you had leave 3 feet from both sides of the house and 7 feet from side with 8 feet from rear, which has not been maintained by you. You are therefore directed to demolish the devious portion of your building within 7 days, my lord. The initiation of the proceeding was initiated at the behest of the present appellant, my lord.
It's all right. It's been initiated now, sir.
My lord, because your last 5 days, 5 years, the writ application is pending, my lord. The present respondent also filed a suit. He has also included me as a defendant number 1. But in this writ application, he didn't include me as a party, my lord. That's why my humble prayer before you to include me as a party in that point. But last 5 years, this matter is still pending, my lord. But without including me, I cannot participate. And
what is your objection, Mr. Mishra?
There is a division bench judgment of our High Court
where it says that suppose there's a complaint. Once the complaint is registered, it's between the development authority and the.
But here you seem to have filed a suit and made him a party and all that.
Yes,
that suit that is independent of this.
No, it's as a result of this.
My lord, the impugned order is supported by a division bench judgment. If my lord would see that judgment,
that is under the
96(1) OLR.
At that point of time, my lord, that was under the Development Authorities Act. You have the Special Planning Authority Act.
Let me just place that. Paragraphs 2, 4, and 6, if my lord would see.
My lord, admittedly, I have the affected person, my lord. He is implicated. Your lordship kindly go through the.
Finish, sir. Let him finish.
Oblige.
My lord may kindly see paragraphs 2. My lord may kindly see.
Para 6. Let's see para 6.
Paragraph 6. The dispute involved in the case at hand is whether there has been any unauthorized development or whether there has been any deviation of the approved plan. It is for the CD authorities to adjudicate that aspect and come to a finding. The applicant for intervention has no role to play in the adjudication and therefore was neither a necessary or a proper party in the proceeding. Both the secretary and commissioner have lost sight of this aspect and so on. This has also been discussed in paragraph 4 in great detail. And unless he alleges some malafides or something or some corruption, then things are different. That's not the case here. This is actually a case where neighbors file complaints against each other.
The affected person, my lord. I am the affected person, and he also can go through the writ application, the plaint. He has also imputed me as a defendant number 1, my lord. Those notice has not the notice and the report which I have annexed to the writ appeal that has not been annexed to the writ application, my lord. Only the plaint as well as the notice of the remolition is annexed, my lord. You lord see, last 5, if the writ application will be allowed and I will not be imputed as a party, my lord, that will lead a multiplicity of litigation. Your lordship knows I have to file a leave to appeal. Thereafter, I can challenge that order in a writ appeal, my lord. If I will be imputed,
what is the nature of the unauthorized construction?
But your lordship, that is a deviation means there is no. They have the construction was made 7 to 8 years back, my lord. They have already closed my windows, my lord. No, your lordship kindly see the report. The 3 feet from both the sides, they have not 3 feet from the both another floor also. They have taken plan for 2-story building. They have constructed 3-story building, and 3 feet from each side they have not. They have already.
There's no setback.
Setback. They have constructed entire plot, which is entirely closed. My windows, my lord.
So, my lord,
entirely closed.
The suit is not involved in the writ. The writ petition is vis-a-vis the developmental authority.
No, you have
so far as the suit is concerned, there's a separate list going on among the parties.
What's the suit about?
You have annexed the writ application. I have said that.
So, my lord,
what is the suit about?
Now, my instruction is that even he has also undertaken wrongful development.
No. My house is 100 years, my lord. My house is 100 years.
Both parties are at fault.
They have not taken any steps regarding my unauthorized construction. They have purchased the land in 2013, and therefore the construction has been made, my lord. Before 2013, my house is situated for 80 years, my lord. My forefather was residing there. In my initiation, the proceeding was in this. If I will be implicated.
What is the suit about? You are not telling
me. Suit is for declaration, my lord. He has implicated other defendants should declare demarcation of the land for western and northern boundary of plot number 147 and the southern boundary of plot 148 as per the schedule of the plaint be passed after demarcation and surveying commissioner. The suit is that, but the shell deed which was they have purchased, they have constructed entire area, my lord. They have let them say they have setback. They have put setback, my lord, in each side. If I will be implicated as a party, there is no harm to him. If I will not be implicated as a party, then it is harm to him because I have to file a leave to appeal. If he will succeed in this case, I have to file a leave to appeal. Thereafter, I can file a writ appeal, my lord.
So facts are almost identical. This one.
No, it's identical because in that is 1996 and now in 2022, my lord.
So
lot of lot of things has been changed. Lots of kind of I think.
Same identical facts on allegation petitioner had constructed ground
last 5 years the writ application has been setback. Your lordship kindly go through last 5 years. The writ application was filed in the month of January 2017. Now we have 2022 in the month of October 2022.
Very interesting. Even in that case, both of them had raised unauthorized constructions.
Yes, that is the altogether different issue. Altogether, both are the raised, my lord. Because here is the case, he has not taken any step. If I could have been made unauthorized construction, they could have filed a complaint, my lord.
The problem would be that this is consistently followed here. This judgment is followed consistently.
No, consistently.
Otherwise, this principle of live and let would go.
My lord,
everybody would be against each other's throat. So from that also, this is now followed. Otherwise, this will open a Pandora's box.
If I have to impede a party, no harm causes to him. No harm causes to him. If I will be impeded a party, what harm causes to him? He can proceed with his case.
You'll become the main contesting opposite party.
Your lordship can be the last 5 years, the writ application has been stayed. No counter from the Jajpur municipality. But I am the worst sufferer. My client is the worst sufferer, my lord. And on the basis of my allegation, the proceeding was initiated.
What has been stayed?
The demolition order which was passed Annexure 4. And your lordship kindly see the last of the order passed by Honorable Single Judge leaves this matter. Your lordship kindly go through this. Put up this matter next week. Interim order passed earlier shall continue till the next listing. That was in 11/7/2017. He could have been any.
No, the writ is probably tagged to this writ appeal.
Yes,
I see.
That is there. That is
so
there.
I'm not making any allegations, but that's probably one of the reasons.
No, that is there.
This judgment is completely this judgment is really against you.
In that case, both the parties are filed, my lord. In that case, both the parties filed their objection that alleging against themselves. But here is a case, I am the sufferer.
Only one person. No.
Your lordship,
so happened that both have raised unauthorized construction.
Your lordship can distinct the case because in 2017, the suit is filed. Here in that case, the suit was not filed, my lord. The suit was filed. I was impleaded as a defendant number 1. His case is that he is claiming the demarcation of the land, my lord, though he has constructed the entire property. Let them say he has not constructed the entire property. The inquiry has been made. He had filed a suit, my lord. The suit is pending. Then if I had impleaded a party in the suit, then what is the harm to implead in the writ application?
That line, my lord, may kindly see. It says that after initiation of the proceeding, the dispute becomes one between the authority and the noticee. That is the person allegedly making unauthorized development. Thereafter, person making the complaint has no right to participate in the proceeding. The proceeding is a statutory one and can only involve the authority and the person making unauthorized development. In such proceeding, the original complainant is neither a necessary nor proper party.
We'll just follow this judgment. You say the short question that arises in the present appeal is whether the learned single judge was justified in reading the plea of the present appellant to be permitted to intervene in writ petition civil 224 of 2017 filed by the respondent. Question mark. Paragraph. Admittedly, it is on the complaint of the present appellant that proceedings for removal of unauthorized construction were initiated against the respondent by the Cuttack Development Authority.
No, Jajpur Municipality.
Jajpur Municipality. And a notice of demolition dated 14 December 2016 was issued by it to the respondent. Full stop. Agreed by the demolition notice, the respondent filed writ petition civil 24 of 2017 in which the learned single judge passed an interim order on 3rd January 2017 staying the demolition notice. The grievance of the present appellant is that since the unauthorized construction raised by the respondent directly affects the appellant, He is both a necessary and a proper party to the proceedings in the writ petition. Paragraph, Mr. Gautam Mishra, a senior counsel appearing for the respondent, has relied upon the decision in Srimati Kirodini Sahu versus State of Orissa, 1996, 1 OLR 387, to urge that the prayer of the present faith. Paragraph, the court notices that the said judgment is in more or less similar facts as the present case. We'll stop there again. The petitioner was aggrieved by an order of the Secretary of the Cuttack Development Authority
No, my lord.
in permitting order of the Commissioner cum Secretary to the government in the Housing and Urban Development Department in an appeal under section 91(2) of the Orissa Development Authorities Act 1982. Permitting the complainant at whose behest the demolition notice was issued to her to be implemented as a party. Full stop. In the said judgment, it is entirely been observed as under A to A. It has further been observed as under. Counsel for the appellant then pointed out that in the present case, the respondent has filed a suit, including the present appellant also as a party. So, be that as it may, the fact remains that in almost an identical factual situation, as far as proceedings concerning the demolition notice is concerned, this court has in Kirodini Sahu versus State of Orissa rejected a similar prayer. Full stop. For the aforementioned reasons, the court is not inclined to interfere with the impugned order of a single judge.
My lord, my appearance may be noted, my lord.
In this case, though the appeal provision is there against the order of the executive officer, your lordship, in that decision 1991(2) of the ODA Act, he preferred appeal. Though in this case, the order against the order of executive officer under section 273, the appeal provides under section 274 under the Odisha Municipal Act, he didn't prefer the appeal. He directly filed the writ application before the honorable court. But in the decision under section 91(2), appeal was preferred.
The writ petition civil 24 of 17 will now be placed before the roster bench.
My lord, I made
directions on 6 December.
My appearance may be noted, my lord. I'm sorry.
For it.
Respondent 2, my lord.
For it.
Item 72.
72, my lord, no instruction. My lord.
No instructions dismissed.
Item number 73.
None appears dismissed.
Item number 74.
May please, sir. But PLA matter, my lord.
74, you have filed a counter.
I have already filed. This is the counter. I also filed the rejoinder, my lord. This case, my lord. And see, my lord, my rejoinder answer 3, my lord.
Ekambra Kanan.
But they, not the petitioner, my lord. So another person, my lord, filed a case before the NGT, my lord. In that case, my lord, order has been passed, my lord. In that case, my lord, the opposite party is also there, my lord, the opposite party. They stated that a counter affidavit dated 3/8/2021, page 12, my lord, has been filed on behalf of the state respondent 1 to 3. They are also party in this present writ application, my lord, stating that petition of the present respondent 30072/2020 has been filed in the High Court of Orissa by way of PIL by one Srimati Jayanti Das, praying for direction to the state respondent not to carry out any commercial project or construct of a high-rise building by destroying the green cover over about 20 acres of Ekamra Canal land. It is stated that the said PIL is still pending before the High Court of Orissa. And on affidavit on dated paragraph 10, 26/10/2021 has also been filed by the respondent number 10, Ministry of Environment, Forest and Climate Change, wherein it is stated that the MOEF and CC has notified that the eco-sensitive zone boundary of the Chandaka Wildlife Sanctuary, Odisha on 9/9/2016, but in order to verify the claim of the applicant that the site of dispute is close to the Chandaka Wildlife Sanctuary, the MOEF and CC has requested the state government to provide the geo coordinates in form of longitudes eco-sensitive zone boundary of the Chandaka Wildlife Sanctuary, Odisha. It is also stated that letter was sent by the MOEF and CC dated 7/5/2014 seeking certain clarification from the state government with regards to applicability of the provision of the Forest Conservation Act 1980 to the land recorded as a forest in SABIC record, subsequently clarified as non-forest in the HAL record of rights. As further direction was given to the government of Odisha to restore the kism of land.
Where are you reading from, sir?
Not the regenter, my lord. In my regenter, my lord, the order was passed by the NGT, my lord. In that case, my lord, the NGT also constituted a committee given report that there is no such proposal of the state government to construct a high-rise committee, my lord. According to that, but here, my lord, in their counter, they have stated that there is a plan for construction of a high-rise building, not the Ekamra Canal, but also the fertilizer farm, my lord, the horticulture farm, my lord. There are two, my lord, though both are related to each other, my lord. Fertilizer farm shows the horticulture farm shows the, my lord, Ekamra Canal, my lord. But in fact, they have stated that there is no such proposal, my lord.
Then that is enough. Why do you want to proceed this?
If the occasion arises, petitioner, my lord,
all right. In the rejoinder.
I am for opposite point of 5 BMC. I support the government.
All right. You see, in the rejoinder filed by the petitioner, enclosed with the rejoinder filed with the petitioner is an order dated 23rd November 2021, passed by the National Green Tribunal in OA case number 101/2020/EZ, in which it has been noted that the government has no proposal to erect any high-rise buildings in the area in question. Since it is in the eco-sensitive zone boundary of the Chandaka Wildlife Sanctuary in Odisha.
My regenter page 13, my lord, paragraph 13 and 14 is important, my lord.
Yes. Apparently, a report requested. No. A report of a joint committee submitted to the NGT, which stated that during field inspection, no construction of high-rise building or other commercial activity was found. Paragraph. In view of the above stand, full stop. Interestingly, the order of the NGT also notes the pendency of the present application, present writ petition. paragraph. In view of the above stand of the government as reflected in the order of the NGT, Mr. Agadal and counsel for the appellant seeks leave to withdraw the petition at this stage, reserving the right of the petitioner to seek appropriate remedies if the occasion so arises in future. This post office is withdrawn with the liberty spirit.
Item 75.
In 75, a learned friend has filed a counter copy not served.
Now, what's the matter about, sir?
That's regarding whether that increment has been granted to an employee who was after his retirement.
Sorry?
Increment has been granted to an employee after his retirement. Our case is that once he has retired, he is not entitled to increment. Relying a judgment, Central Administrative Tribunal, which has been confirmed by that Madras High, that this order has been passed, so that judgment is not applicable to our case.
Copy of the counter affidavit will be served on
Sorry, today. Now, just
has been served upon the counsel of the state today. Rejoinder, if any, be filed before the next stage. 7th February.
List item 6. May please the lords. Now here the petition is the Sarpanch in schedule area. Now challenges the grant of license under Annexure 11 at page 32. Now it is for the license has been granted for the year 2023 without issuing the public notice, which has been under RKA. It has been informed by the Superintendent Excise under Annexure 12 at page 34. No public notice has been issued for the year 22-23. Without issuing the public notice, which is mandatorily required under section 20 and 27. Now here, two notices to be issued. One public notice and
notice not been issued.
What happened, earlier occasion, this present petition has filed another PAL. Your Lordship has been pleased to post it on 7th December.
That is regarding privilege. It is not here challenge the grant of license.
Same point. Mr. Monty accepts notice for respondents 1 to 4.
I am for the OP number 5. Already entered appearance.
Right. For notice for respondent 5. Opposite party number 5. Replies be filed within 4 weeks. Rejoinder for the next date. List along with
WPC number 16813 up 2022.
That is not posted to 7th
December.
On 7th December. All right.
We list for orders item 77.
Already started functioning since July.
Section 27.
Notice on the COs. All right.
The Lordship has issued notice on 28 on 2022. None has appeared in this case. The first day
service complete.
On the very first day the matter has been disposed of.
Despite valid service and for the respondent, the delay is condoned. The reason stated that.
In fact, there is no delay, my lord.
Yeah, it's all right.
So sorry, my lord.
The impugned order, it is seen that the impugned order has been passed on the very first day with the learned single judge without any opportunity to the present appellant to file a reply. So on that short ground, the impugned order dated
6/2/2020
is hereby set aside and petition civil 2991 of 20 is restored to the file of the learned single judge to be proceeded with in accordance with law. Full stop. The said petition will now be listed before the learned single judge on 9 January 2023. So further directed that by 30th January 2022, the present appellant would file its paravis reply to the writ petition, and the writ petitioner will file a rejoinder thereto before 9 December 2023. Sorry, 9 February 2023. No further time will be granted for that purpose. The learned single judge is requested to expeditiously dispose of the writ petition as dispose of the writ petition as expeditiously as possible, and preferably within a period of 4 months thereafter. The writ petition is disposed of.
Item note 78. Item number 78.
I'm 78. Kindly 3 days time may be allowed to remove the defect.
All right. Consider the
3 days time.
appellant seeks 1 week's time to remove the defect. List thereafter.
Weekly list for orders item 79.
In this case, your lordship, the petition appellant filed a petition for release of for bail, your lordship. The appellant is inside the custody since 31/8/2013.
Paper book is ready in this, my lord. So,
Lordship, since long he is inside the custody, only pray your lordship for some days maybe release some.
This is circumstantial evidence, but 302, 304B, 498A.
Yes, your lordship. This only circumstantial evidence. On the circumstantial evidence, the present appellant is convicted, and the fact remains, your lordship.
Are you ready to argue the appeal?
I am ready to appeal, but I have not brought some judgment. No, the fact remains the doctor has not been examined.
No, you will argue tomorrow?
Only day of next week. Can you
at the request of counsel, the appellant list on. November 2022, when he's prepared to argue the main appeal itself.
Item number 80.
This is the case your lordship remembers. This is a case remanded from the Honorable Supreme Court, wherein the association.
Correct. Who's for the respondent? State.
State.
Who appears for the state, Mr. Budli?
oh, wait, let's show that way. 79, 80 to 80. 80. 80 more. Yeah, I'm holding the bill for Mr. Katkia, my lord. He's out, but nevertheless, my lord, your file and supplementary affidavit has been filed.
I know, but he has to be ready to argue the matter.
Day after tomorrow, my lord. So Mr. Katkia will be doing the matter, my lord.
All right. You stated that Mr. Katkia, who appears for the state, is in some personal difficulty today. Not day after. 19 January. All right.
Weekly list item 81.
Item number 81 on behalf of Mr. Malord, Pinaki Mr. Senior Malord, he has requested Malord any day next week, Malord. He was supposed to appear through VC, Malord. I am extremely sorry, Malord. Can it be we may accommodate to next week, Malord?
Next week is not possible. At the request of Mr. Pinaki Mr. and counsel appearing for the petitioner.
Malord.
14 February.
In this case, posted to 14 February.
Yes.
All right.
All right.
Weekly list item 82.
Suffered a lot of adjournment.
82.
Before my friends start, my lord, there are two connected appeals, writ appeal 24 and 490 of 19. There I am the appeal there. Those two persons have retired since, this is a case of transfer. They have retired since 2020. One in March and another in June 2020. So, my lord, taking this judgment, that first case, that review judgment taken into consideration pass order in another case, because this is virtually academic. Whether the what the my lord have said, this is the dispute was whether the director of higher education has the authority to transfer the employee of the junior college lecturers or the director of higher secondary. That was the division bench of this honorable single bench as well as the division bench has said it is the director higher has no jurisdiction because he has made the transfer. Against that, they have filed the review in that Binod Jana's case. My friend is there for the Binod Jana. But my clients have retired already. This is virtually becoming academic. That is why my lord have passed this order. Kindly see. By taking note of that facts also, you can dispose of it in that light. Say, identical order may pass. Same. So they have retired. They have also, these two persons has also been allowed to join. Only the salary they have to get and pension. 2 years they are suffering.
So far the review is concerned, my lord, I am appearing for the opposite part number 1, my lords. And there is opting, my lords, that in the meantime, opposite petition number 4 file an additional affidavit, my lord. That has not been served to me, my lord.
My lord, that additional affidavit in the review, your lordship, this honorable court directed to file an affidavit. We have filed an affidavit with regard to whether the order of transfer which has been passed by the director of higher education was in concurrence with the director of higher secondary education or not. That affidavit we have filed that the concurrence of the director of higher secondary education has been taken. My lord, here the moot question, my lord, the present opposite party, he is the original employee of the higher education. When the +2 wing was merged with the school and mass education, certain employees were sent on deployment to the school and mass education department, having all the cadre controlling authority with the higher education. So according to that cadre controlling authority, the order of transfer has been passed. The honorable single judge has taken note of that and dismissed the writ petition, did not interfere in the order of the transfer. But in the division bench, in the writ appeal, this honorable court passed an order that even though that order is there, once they brought to under the deployment of the school and mass education department, the higher education has no authority to pass the order of transfer. So order of transfer is without jurisdiction. That order we have sought for review, that the documents
so what has happened in the meanwhile? They went on transfer or did not go on transfer?
My lord, the person who was transferred vice the present opposite party, he joined in the place of posting. So order of transfer has already taken its effect.
Question open.
Is that for my clients are concerned, they have retired. They have joined, but they have been.
But the only
to join
the academic. That is the only question.
On that decision, in review petition 1 of 2019, it is stated that the respondent is already joined.
No, my lord. So for the respondent,
the person who was
so for my client is concerned, he is also in the meantime retired, my lord.
Oh, it says that the respondent is already retired, rendering the question infructuous. The question of law raised in the review petition is left open for decision in some other appropriate case. Then what about 21388? Who's appearing in that? It's your client.
Yes. That was disposed of case.
Disposed of case.
But so that writ appeal is there.
No order need to be passed. Then in the remaining writ appeals, both writ appeals, you say the respondent in both these appeals have retired.
And they have been joined back in their own original institution.
Yes.
Where from they have been transferred, they have been allowed back to join. That order of the single judge has been implemented.
Okay, it is stated that the order of the single judge in both these cases has been implemented.
Yes.
In that view of the matter, leaving the questions of law open for decision some other appropriate case, the writ appeals are disposed of.
There seems they have been retired, my lord. They are not getting, because of the pending of this case, we are not getting pension and other.
Anyway, now you say in the contempt case, you say now that the consequential reliefs in terms of the impugned order of the learned single judge and the retirement benefits, if any, be disbursed in accordance with law without any delay.
That is also in respect of my case also, my lord.
All right.
And so far, my lord, my instruction is concerned that my client has not joined in the place of transfer.
We are not now.
Yes, my lord.
No need to say all this, sir. Yeah.
Weekly list item 83.
That's 83. We have filed a counter affidavit today.
Copy has not been served, my lord.
As I'll serve.
Copy of the counter affidavit filed.
My lord, I am appearing on behalf of OP number 2, my lord. The petitioner be served a copy with copy with me, my lord. We have not.
My lord, I'll serve it. By course of the
copy of the counter of the state government being filed today be served on counsel for the other parties.
Okay, I am
rejoined for the next date. Copy of
I'm appearing for respondent.
OP1, my lord.
Petition be served on counsel appearing for respondent 2.
I am for OP1.
Opposite party number 2.
Opposite party 1, I am appearing. Counter copy is served to the petitioner, my lord.
So both of you are Union of India?
Yes, department different, my lord.
Two different
So anyway, serve on both counsel appearing for 1 and 2. All right.
Lordship, I'm appearing for the project proponent, respondent number 5, my lord.
Yes.
Lordship, give me one opportunity. Now that we have the state counter and the central counter, give me some 2 weeks time to file the counter.
All right. Counsel for the opposite party number 5 is also permitted to file a reply within 4 weeks. Rejoined for the next day.
I'm sorry.
My lord, I have filed a IA 5949 of 2022 for impleading certain petitions
No, individuals as petitioner in the writ application.
All right. The reason stated the application is allowed. The amended cost title be filed within a week.
Obliged, ma'am.
Based on 15th February. Right.
Obliged, ma'am.
Weekly list item 84.
84 pursuant to last order. The order dated 12/7/2022. And I have filed 2 affidavits. It has already been e-filed, but however, since it is not in the record, I'm filing the hard copy. The first mailer may take the affidavit dated 13/10/2022. That is filed by the Superintendent of Police, DG office. That you will say paragraph 3.
1 minute. We don't have that. We have the para 3.
Para 3.
Correct.
And in the paragraph 3, we have stated that
advertisement for recruitment of 143 sub-inspectors.
Written examination has already been completed and the physical examination is under progress.
All right.
And in the sub-paragraph, we have stated that so far as further recruitment to 47 numbers of SI of police.
All right.
Then in paragraph 4, we have stated about government permission to fill up.
All right. You say an affidavit dated 13th October 2022 has been filed by the Additional Superintendent of Police, listing out the progress in the filling up of vacancies in the ranks of ASI and constables. No, ASI, SI and constables. It is stated that immediately after completion of the process, the vacancies in the different marine police stations will be filled up. Then what else?
And then another affidavit by the Fisheries Department.
Where is that?
There, my lord, we can see paragraph 3, we have stated about the tender process which was initiated.
Transponders.
Yes, for transponder, but that could not be materialized. Now we have gone for an alternative method that we have stated in paragraph 6. That earlier a pre-bid meeting for request for proposal was held under chairmanship of Director of Fisheries Odisha Swansea through VC mode. Said meeting was attended by one vendor, Mrs. Sankhya Labs Private Limited, Bengaluru, and suggested that the transponder terminal operating on ISRO's GSAT-6 satellite are meant for defense and strategic application, and the procurement model of such transponders should be business to government and not business to consumer in the interest of national security and fishermen safety, as bandwidth cannot be allocated to individual consumer. Accordingly, the Director Special Project ISRO, Bangalore, was requested by letter dated 21/6/2022 of the Director of Fisheries for allocation of bandwidth in GSAT-6 satellite to 1740 mechanized boards for execution of the project, and with a further request to apprise the ISRO empaneled vendors for participating in the RFP process. In response to the letter dated 21/6/2022 of the Director of Fisheries, the Director Special Projects ISRO, by letter dated 13/9/2022, clarified that the GSAT-6 satellite is meant for the use of strategic users for their communication purposes. Since the two-way MSS communication system for sub-20
Anyway, this is a long narration. So basically, you are asking the BSNL to revisit the entire proposed cost of transponders.
Yes.
All right.
At page 16, the ISRO is ready to provide the bandwidth. Now only the
transponders.
Cost analysis is left on the state government. The infrastructure is to be provided by the state.
An affidavit dated 14/10/2022 has been filed by the Director of Fisheries, by the Deputy Director of Fisheries (Marine), where interior it is stated that BSNL has been asked to revisit the entire proposed cost of terminal transponders. It appears that ISRO is already prepared to provide the bandwidth.
Yes, they have written it.
But only the transponders have to be procured. Stop. 3 months' time has been sought for providing transponders, network infrastructure and bandwidth. What's up? List on. First March.
My lord, which date is my lord fixed? My lord is fixed.
First March, sir. First March.
Oblige, man. Oblige.
Weekly list item 85.
Item 5. I am appearing for respondent, my lord. 1 week time for filing of written note and final hearing, my lord.
Page 35 is the order. First day disposal, even punishment has been imposed. Despite that, Honorable Single Judge are directed to give him promotion.
When are these coming up?
That 28th.
28th October.
Yes, my lord. Here, my lord, the punishment has been imposed. In those cases, my lord, discipline proceeding is pending. Your lordship may see Annexure 1.
Anyway, 28th. It's a 28th October.
My lord. And first, this is the first day disposal.
Yes.
Item 86.
I may be pardoned to submit, my lord, that I file an amendment petition 4946. Only photograph of the Chhatrapur main station and the rule, my lord. That may be allowed. But my lord has given instruction to give instruction to Union of India. People are suffering, my lord, like anything. See, because danger to life to come to foot over bridge, construction of foot over bridge, my lord, in Chhatrapur main station. That already, my lord, directed to take instruction to Union of
Yes, Mr. Pari.
Yes. I have not received any instruction. May keep more time.
At the request of Mr. Padi, who needs more time for instructions, list on 13th December.
My lord, that amendment petition of
that amendment is allowed. All right. For the reason stated, that 4956 of 2022 is allowed. All right.
My lord, already.
87. 87.
My lord, in this matter, my lord, the government haven't filed any counter, my lord.
Because on the last occasion, my lords had asked us to not go ahead with the demolition. So that, my lords, on instructions, we have not demolished any of the. Today, my lords, if my lord sees the last order on the first paragraph. However, the grievance is that the NGT has directed demolition of the civil structure. According to the petitioner, he is prepared to put to use for a different purpose, which is non-polluting. He states that he will file an affidavit in that regard before the next date, because only on that basis, my lords had granted that state.
Where is your affidavit?
My lord, my senior was not well, my lord. I just got he was present over here. He wasn't well, he just went home, my lord. And,
No, why have you not complied with the order? You have to file an affidavit, sir.
My lord, but I am assuring that we are going to file the affidavit within this week.
Counsel, the petitioner states that he will file an affidavit in terms of the order dated 30th August 2022 within a week.
My lord, obliged.
List on 29th November.
Password matter. Weekly list past or matter. Item number 6.
May I please, your lordship, on behalf of my senior, Mr. K.K. Rao. My lord, due to some personal difficulties, he could not able to come to this honorable court.
All right.
So praying
Mr.
for
Rao
next week.
stated to be in some personal difficulty today. It's on 31st January.
Past or matter. Item number 9.
My lord.
What's the distance, sir?
That is 3 kilometers, my lord.
Nothing, sir.
Just
That's what thought as much.
One clause I will show, my lord. One clause, my lord.
We're not interfering these
Notification, my lord. That is.
Sorry, sir. We're not interfering.
Just one clause, my lord. Just one clause. Page 19, clause 10, my lord. That is the guideline, my lord.
Right.
My lord, just for a moment, my lord. Clause 10 only.
Yes.
Page 19, my lord.
Carry on.
The following priority shall be given to cover the village as GP headquarters. Population of 2,000 and above as first priority. Population of 1,500 and above as second priority. Population of 1,000 and above as third priority. In 2 or more villages come under the same category, then other things will be counted, my lord. Here, my lord, page 21 is the report, my lord, where that population is given, my lord. Page 23, my lord. Here, Jungapali has 1,707 villages, 7 population, my lord. And there is no other village with the same category, my lord. So as for clause 10, the priority should be given to the Jungapali. And accordingly, the notification was issued, which was subsequently modified in a region.
The only short question is whether the headquarters of the Gram Panchayat should be at Junjupalli or at Tal. So admittedly, the distance between the two is just 3 kilometers. In the circumstances, the court is not willing to interfere in the matter. The impugned order of the learned single judge is affirmed. The writ appeal is dismissed.
Pastoral matter item 38.
In item 38, I am for the respondent number 1 only.
Or
contesting
none appears for
respondent.
the appellant dismissed for non-prosecution.
For hearing, item number 88.
It is now, my lord. Another item day after tomorrow. Kotkia is not there, my lord.
No, I'll be
Yes.
doing it. If you take it up, I'll do
My
it.
lord. Already I have argued on that day. My lord.
Correct.
It will take some time, my lords.
Tomorrow or day after, whenever you want.
Day after tomorrow, my lord.
Day after, or list day after.
Item 89.
My lord. My lord, Supreme Court was the director to dispose of this matter stipulated period, my lord.
We'll start, sir. We'll continue tomorrow. We start now.
4:20, my lord.
Whenever, every time is a good time, sir. Tomorrow you want to do
Tomorrow
it?
2 p.m. my lord, fix.
No, fix and all. You be ready. We'll take it up tomorrow. 90 also day after.
Not 90 minutes, I have not received the paper book for 1 week after.
All right. In 90, you say the request of Mr. Agada list on 27th October.
Obliged.
All right.
All right.